left of some significant work. We will start back where we left off from this morning, which is the review of non-compete clauses. We do have Representative Stiff with us online. Representative Stiff, thanks for hanging in this morning and recognizing we're a little late on our agenda. I know you're in joint appropriations as you're a member of that committee, so appreciate your flexibility and appreciate you being here today. The floor is yours, Representative Stiff.
Madam Chairman, thank you so much. Can you hear me okay?
We can, yes.
Great, thank you. I'll try to be quick. Thank you for considering this topic. So what are the problems that we might try to solve with proposed legislation about non-compete clauses? Current law works, but it has two features that are perhaps unfortunate. The first is that it's entirely judge-made law on covenants not to compete, as you saw in the memo that I believe Mr. Fuller prepared for you, which was a good outline of what the current state of the law is. Part of the problem is that under the Supreme Court's decision of CBM Solutions Inc. versus Geotech, there are 12 separate factors to determine whether a covenant not to compete is enforceable or not, with no particular priority set for any of those 12 factors. So a result of that is that when you have 12 factors to decide something, you can get very different results from similar cases, which makes the law unpredictable to that extent. You saw in the materials handed out, for example, that non-competes to be enforceable right now need to be limited in geographic scope and limited in time. And yet we have a Supreme Court opinion from 2001 that says that upheld a covenant not to compete that banned a person for life, right? So you get a lot of disparate results, which from a practitioner's point of view means that if I draft a covenant not to compete for somebody, I can do that, but I can't really tell the client whether it's going to work or not. And so it's to that extent inefficient. So that's one feature of our current system. The other feature of our current system is that it's being applied to what we think of as sort of everyday laborers, nurses, welders, as well as other professionals, doctors, and the like. So to take a recent case that happened, and what that does is these covenants not to compete, they restrict a person's freedom, of course, from practicing their profession, right? So for example, last year, some nurses who had been nurses, home health nurses, and over in the southwestern part of the state in Uintah County, they'd been home health nurses for decades, but they had signed a covenant not to compete as part of their employment agreement. They didn't feel like they had a lot of bargaining power on that, right? They just, if they wanted to keep their job, they needed to sign the covenant not to compete. So they do that. And then during the coronavirus pandemic, when the need for home healthcare services is pretty high, they quit their jobs there and go to work for a competitor. And the district court judge said, well, sorry, you signed a covenant not to compete, so all of you are out of work now. So we took 3 nurses out of the home healthcare sector in Southwest Wyoming and during a pandemic. And that seemed like a sort of an unfortunate result of the current state of the law. Part of the materials submitted to you is a proposed draft of a bill that I had done, LSO kindly did last year, and I decided not to introduce it because I thought it got a bit complicated. There's nothing particularly magic about that particular draft, but if you do take a look at it, the core piece of it's on page 2 at the top, and if I've got the language right, it says, every contract by which a person is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void, except as provided in this section. So what this would do basically is outlaw covenants not to compete and then create exceptions. And so is that a good idea or not? I guess that's for you to decide. You do need certain exceptions because there are situations where it's common sense and entirely practical to have covenants not to compete. If you've got a dry cleaning business that you've run for a couple of decades and you want to sell your dry cleaning business, well, the buyer wants to know that you're not going to set up a competing dry cleaning business across the street immediately after they sell it, because a lot of the value of what the person's buying are the customer relationships, the customer goodwill, that expectancy of future income, right? So that's an exception. Certainly it makes sense also for an employer not to lose their trade secrets, right? So that's kind of a carve out as well. One carve out that's listed in this draft bill also would be to say, look, if the employer has spent a lot of money on this employee to give them some specialized training, say you send a welder and you're the employer and you spend $8,000 to train that employee to do high pressure hot tap welds that are very dangerous, but also very lucrative if you can do them. Well, the employer may want to get some return on his investment. And this bill doesn't entirely solve that problem, okay? But it does say that if the employer were to pay out of pocket like that, that the employer could have a contract saying, hey, if you leave me in the next 2 years or 3 years or whatever the time duration is, after I've trained you, that I can get my costs of training you back. So that's it. It's kind of a big, interesting topic, I think. There are a handful of states, as I think the memo outlined, have outlawed them. California's outlawed them. Colorado, I thought, had an interesting one, because it seems like Colorado says that covenants not to compete are not valid, but then they make a carve out for executive management, which I think is an interesting kind of carve out. You may want to think about that. But I appreciate your time, and I will I'll stop talking and stand for any questions that any of you may have.
Thank you, Representative Stith. Questions for Representative Stith? All right, seeing no questions for you, Representative Stith, please stay close on this topic. I think we'll probably come back around to you for some thoughts.
Thank you.
Is there any further public comment on this topic? No one wants to talk about covenants not to compete? Curious? All right. All right, public comment is closed. Committee, back to you. Discussion? Are you awake?
I'm awake.
Representative Yin.
Thank you, Madam Chair. So I think as a point of discussion, I do think it's odd that we just leave this in case law when the case law said it was decided on consideration of a matter of public policy rather than basis of any constitutional or statutory provision. So I do think it'd be interesting for the legislature to take it up. I don't know if I feel like I want to make a motion for it or not. I would also entertain it as a personal bill at some point if it came from the representative, but I do think it'd be also interesting for the committee to take it up. So that's just my discussion point. Thank you, Madam Chair.
So Representative Stith, I'm going to bring you back here for some discussion. One, to probably help focus the conversation a little bit more thoughtfully. In my practice, I've certainly seen these covenants not to compete in a variety of professions, and curious to hear your feedback. One, as it relates to medical professionals, to waste management, 3, food service workers. So a shocking array of professionals. Veterinarians love these particular contracts. I've litigated a number of them, represented a number of them, and it's always surprising, particularly for Wyoming, a rural state who needs many of these professionals, that they would then get boxed out for a variety of reasons. There was one particular business that the owner sold it. So new ownership came in, and they therefore adopted the contracts and covenant not to compete with the professional employees that they had in place. Well, the relationship with the professional employees and the new owners was not ideal, but those current employees, those professionals, couldn't leave. They couldn't get employment doing that particular skill within the entire Cheyenne community, Laramie County community. And that seemed like the wrong result. And so there are a number of these types of situations that occur, I think, frequently. And so I think that's why, Representative Stith, you brought the bill. And so just to kind of show the broad scope of the different businesses and occupations that can be affected. And the reverse, the balance side of it is the private ability to contract, right? And to contract for your rights, which is fundamentally important, to protect your business and business relationships. And so certainly the need to strike a balance, which I think the case law and of course this bill attempts to do, recognizing those unique interests that are presented. Representative Stith, any further comments?
Madam Chairman, thank you so much. I think if the committee were to take up this topic and were to end up with some kind of legislation that may not be like the proposed bill, but something different, the result would be to make the labor market a little more fluid. And I think that could be a good thing for Wyoming. Because, for example, the nurses I was mentioning in Uintah County, one went to Pennsylvania, another one to North Carolina. And so here without really, and there's a potential damage to the public, especially in the healthcare sector, where you don't have a lot of providers already. And then if you have these agreements that effectively encourage people to leave the state, that seems undesirable. The same is true for welders. A bit of history that you're probably all familiar with is that a few sessions ago when we were in the Jonah building, Representative Nicholas had brought a similar bill, but it was limited to physicians. And I believe that passed the House, but did not survive in the Senate. The fact that it passed the House, I thought, meant that there might be some impetus and some opinion that it's worth taking a look at this area of the law to perhaps to reform it. The Federal Trade Commission actually has been asked to look at this on a national level to see if there should be a rule nationally that would outlaw these. It doesn't sound like the Federal Trade Commission is going to go that far, but I think the trend across the country is to recognize that for the most part, there's generally very unequal bargaining power between the employer and the employee needs a job. Sometimes they already have the job, and when presented with one of these covenants, feels like they have to sign, or they're going to be out of a job. And so that unequal bargaining power is I think a problem. So the idea here would be to make the labor market more fluid, to keep our workers here in Wyoming and not have them have incentive to leave the state. So.
Thank you, Representative Stith. Senator French.
Thank you, Madam Chair. Representative Stith, are you proposing, and I see where some changes need to be made on it, but if there are changes, would the current contracts that employers have be grandfathered in?
Representative Stith.
Madam Chairman, Senator French, that's a great question. It's my understanding that there's a constitutional dimension to this. In the U.S. Constitution, the Contracts Clause says that the government cannot pass laws that abrogate contracts. So as a result of that, you would have to make it prospective, and you would have to say that, were this to become law, that, for example, it would only apply to contracts entered into after, say, July 1 of 2022, for example. So if the committee were considering it, maybe there'd be a rush by employers to get them all buttoned up and signed up by June 30th of 2022. But I think hopefully that answers the question.
Further discussion, Senator Kolb.
Thank you, Co-Chair Endicott. Just a general question is, it looks like, Representative Stith, that we have a hole in the law when it comes to clarity. I mean, there's not clarity on this, and we have constantly, I guess, work going back to the attorneys, which I'm always in favor of limiting. And I think this might go a ways to do that. So I think we do need clarity. It seems like, in a broad way, an employee protection issue when it comes to being forced to sign an agreement, especially after you're already in employment. And in order to continue your employment, you have to sign a set agreement, which then restricts you in finding further employment. So I think I don't know the current draft that you would like to propose wouldn't be the same as what would come out of this meeting or these meetings. But I think I would be curious and interested and supportive of moving forward with this topic. Thank you, Madam Chair.
Representative Swanitzer.
Thanks, Madam Chairman. I would move that we draft 21 LSO 272, working draft 3, to be a committee bill for our next meeting to review. As part of that motion, I would also ask LSO to define specialized training on page 3, is that policy memo, as well as also defining substantially all. I don't think that's the right word choice, but if LSO could come up with either definition of substantially all or a better way to phrase that sentence on 9 of page 5, and then obviously move the effective dates back to 2022 would be my motion.
Seconded by Representative Washit. Discussion on the motion. I just want to make sure, and this is a legitimate question. It's not, it is not rhetorical. If you have compared that with some of the other states' laws concerning the issue, and if you prefer the bill draft that Representative Stith prepared, or perhaps South Dakota or Colorado's version, just making sure that we do the right bill draft. And Representative Stith, did you have a preference on those other states?
Well, Madam Chairman, obviously, I think my word's the most beautiful of all, so I would like my version, obviously. As background, I would add that for the most part, I started with California statute, and then I added in a couple of other exceptions. That's how this draft got here. But, you know, I don't have any particular extraordinary pride of authorship. So the fact that if the committee will take up the topic in some version of it, I think would be most welcome.
Further discussion? Co-Chairman Olson?
Thank you, Madam Chairman. Just so Senator Kolb fully sees the results of what could happen, we limit the work to lawyers. I think that just increases the hourly rate for lawyers if they have less cases.
I'll take that chance, Co-Chairman.
All right.
All right, further discussion. Representative Swanitzer.
Thanks, Madam Chairman. And I'm okay with the draft before us, even though I tend to like Colorado's, but what I would ask is if we could maybe do some research from LSO on that geographic restriction boundary that other states have put into place. And I know some are profession specific, but having a better idea of what other states are doing on what the geographic boundaries are, I think is important. So if that could be incorporated in the motion, and we may need to alter the current limits or restrictions in the bill based on more information.
All right, further discussion on the motion. Senator Cost.
Thank you, Madam Chair. In my thinking as well, I think something that could be a detriment to the proprietorship of something such as a program or something like that is important to make sure you're protecting against. But I really struggle with things like building an office or a building across the street when that should be a right. So I think we've got to look at how we can define that stuff to try to narrow it down so that the freedoms of people to be able to do some things is still there. I think we don't want to have that limit where it is like now hurting everybody. So
Thank you, Senator Cost. Any further discussion? Question being called. All those in favor of Representative Swanitzer's motion to have a bill draft reflecting 21 LSO 272, please say aye.
Aye.
Any opposed, say no. That motion has passed. All right, committee. Any further discussion on this topic? Seeing none, we will go to our next item on the agenda, bias crime reporting requirements. We'll start with the LSO topic introduction. Please.
Madam Chairman, Committee, Danielle Creech, LSO. So today I'm going to be talking to you about the research memorandum found in your materials entitled Bias Motivated Crimes, Definitions and Reporting Requirements. And before I begin, I'd like to note that this report is a 30,000-foot view of the issue, and it does not dive into the wide range of nuance within each of these state statutes. So while these state statutes are listed in the table under a column entitled penalty enhancements, some states have automatic sentence enhancements, some are optional, some include bias motivated crimes as their own crime. And some even have, civil penalties associated with bias motivated crimes. The purpose of this report was to focus really on which bias motivations are included in states' bias motivated crime laws, and also the data reporting requirements both at the state and federal level. So with that being said, a little bit of history behind this is after the passage of the Civil Rights Act in 1968, the Department of Justice began prosecuting federal bias motivated crimes. Major expansions to the federal hate crimes definition included the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009, Damage to Religious Property Church Arson Prevention Act, and the Hate Crime Statistics Act, excuse me. There are 2 federal reports that standardize and publish state bias motivated crimes data. The first is the Uniform Crime Report, and the second is the National Crime Victimization Survey. The Federal Hate Crime Statistics Act requires the United States Attorney General to collect data about crimes that manifest evidence of prejudice based on race, religion, sexual orientation, or ethnicity. The Attorney General appointed the FBI, Federal Bureau of Investigations, as I'm sure you're all aware, to develop and implement this program, which they assigned to the Uniform Crime Reporting System. The infrastructure was already in place to report other crimes, and so they added those bias motivations into that reporting program. Neither the Uniform Crime Report or the Hate Crime Statistics Act requires agencies to submit data, and there are no financial incentives to do so, which can impact the ability to compile comprehensive national data regarding bias motivated crimes. Further, because not all states have bias motivated crime statutes, as you all know, or because statutes generally include different bias motivators, as you'll see in the table included in this report, aggregating and comparing data across states leads to significant challenges. The Uniform Crime Report reports that in 2019, 15,588 law enforcement agencies in all 50 states did participate in reporting in the UCR. To facilitate data consistency across law enforcement agencies, the FBI provides a comprehensive hate crime data collection guideline document, which I have included in Appendix A as a separate document. The Department of Justice also collects data on bias-motivated crime victimizations through the Bureau of Justice Statistics National Crime Victimization Survey, which I previously mentioned. And this report relies on victims self-reporting their victimization and thus does not require a prosecution in order to be included in the published data. Most states do have bias-motivated or hate crime statutes in addition to federal law that include a range of different bias motivations such as race, religion, ethnicity, sexual orientation, gender identity, and disability. Additionally, most states have penalty enhancements written into laws that increase the sentence for crimes motivated by those identified factors. Some states have also implemented statutes requiring law enforcement agencies to report bias-motivated crimes to a centralized organization or agency at the state level. 30 states have specific data collection and reporting requirements for bias-motivated crimes. Although many law enforcement agencies willingly comply and participate with the UCR reporting at the federal level, states utilize data reporting statutes as an additional mechanism for compliance and a way to ensure data integrity and consistency. Some states require law enforcement agencies to report directly to the FBI, while others require the development and implementation of an in-state reporting system. For example, New Mexico requires every district attorney and all state, county, and municipal law enforcement agencies to provide the FBI with data concerning the commission of a crime motivated by bias. Utah law requires their Bureau of Criminal Identification to establish statewide uniform crime reporting systems that includes, among other things, reporting statistics concerning crimes that exhibit evidence of prejudice. Table 1 begins on page 4, and it does provide details about each state's statutes as well as the bias motivations that are included in those state statutes. And in the final column, you'll find the statutes that determine data reporting requirements. I would like to note 2 corrections in the table, thanks to the help of Representative Provenza. The first is North Dakota. North Dakota does not have a penalty enhancement statute, and the statute there included is quite similar to that of Wyoming's, but is often not acknowledged as a hate crime statute, much like Wyoming. The other is Minnesota. I left out the actual penalty enhancement statute, which is Minnesota statute 609-2233. With that, I'd be happy to stand for any questions.
Thank you, Ms. Creech. Any questions for Ms. Creech? Representative Swanitzer?
Thanks, Madam Chairman and Ms. Creech, and I'm directing the question at you, but I'm really kind of setting the game for some more questions I have coming. In your chart, when we list which states have bias motivated crimes and hate crimes, on your chart, Wyoming is blank. As I'm sure in your research, there have been some assertions and advocacy that 69101 in our statutes, I think it's 69101B, should arguably count towards us, in fact, having some form of misdemeanor penalty, at least for these type of crimes. I was just wondering if you went through that and you made a determination based on any factor of why that should not count, or if this is from another organization nationally that doesn't seem to count 69101. I don't know if you can answer that right now, but I do think it's interesting. We have an argument out there that Wyoming does have a hate crime statute from the 50s. Just any research you did on that and any determination you made if that counts comparable to other states.
Ms. Creech?
Thank you, Madam Chairman, Representative Swanitzer. I did include a footnote, I believe it's 69102. And I did do quite a bit of research looking into various national organizations that classify whether or not states have hate crimes in place. And, you know, unfortunately, I don't have an answer for you as to why these national organizations don't classify Wyoming's statute as a hate crime. And that might be something better directed toward, you know, those prosecuting or using this statute in practice. But as Representative Provenza and I discussed, North Dakota does have quite a similar statute. And similarly, in these national organizations, they are classified as not having one either.
Ms. Creech, Representative Swanitzer, it appears like on this table that this concerns penalty enhancement statutes. And so that's what the focus is on, not necessarily the crime itself. Penalty enhancement, right? So maybe there's a distinction there between a penalty enhancement as opposed to a crime.
Madam Chairman.
Co-Chairman Olson.
And that, I think Danielle, you answered, I was going to ask this question for clarification purposes, but I think you answered it in correcting those 2 states, because I wanted to be sure I was reading this table correctly, as the co-chairman points out, because I think I think we're confusing the language when we say Wyoming is the only state without a hate crime statute. That's false, absolutely false. Whether it's a penalty enhancement statute, I think is a different question. So all I want to confirm is that all these states that you have listed, you pulled out North Dakota because its statute is not an enhancement. Maybe this is a question for Mr. Fuller. It's not an enhancement. It's a standalone charge. Is that accurate?
Ms. Creech.
Madam Chairman, Mr. Co-Chairman, many of these states, it is a penalty enhancement. And as I said, a majority of these states, you know, that I listed, I didn't go into the nuance necessarily of which penalty or, you know, which crimes have penalty enhancements, or whether some of these bias motivated crimes do stand alone. But on the whole, I'd have to refer to our legal counsel in order to give a comprehensive answer as to why Wyoming isn't classified that way.
Well, Madam
Follow-up?
Chairman, then I think, Mr. Fuller, we need to, I don't know, you probably have, I don't know if you've looked at every single one of these statutes, but if some of these states and the statute we list is not a penalty enhancement statute, then we just simply need to correct our materials. It shouldn't say penalty enhancement statute. If some of them are and some of them aren't, or can you confirm that all of those are?
Chairman
Fuller?
Olson, or Madam Chairman, excuse me, Chairman Olson, we will look at that. I mean, if the committee so desires. I'll note this. Some states, including some of the states listed there, do have, I guess, what I would characterize as a true penalty enhancement.
I saw you right now, but I think it is very important to make that distinction.
Madam Chairman, Co-Chairman Olson, I can tell you that, some of these states do have an automatic penalty enhancement for those crimes that are deemed bias motivated. Additionally, those states that are listed as separate crimes, oftentimes when it's separated, it's a separate offense. It tends to be tailored, consisting of assault or harassment crimes, and rather than a sentence enhancement, this can be, a sentence enhancement that can be granted to a wide variety of crimes. Rather, it's an enhancement to those specific crimes, if that can answer your question.
Yes, Madam Chairman, Chairman Olson. I'm not sure if she will be commenting, but Ms. King did provide an additional material that I think Mr. Chairman Olson gets to your question. That is 10-02 on the meeting materials. I believe it would have been handed out yesterday, but if not, it is online.
Thanks. And Ms. Creech, if you know, are most of these felony enhancements level, or are they misdemeanor enhancements to a felony level crime? Or can you have a misdemeanor enhancement to a misdemeanor? It's not really clear on the spreadsheet, but any anecdotal as you're going through, if these are all felonies with additional felony level provisions, or do some people throw misdemeanors on a felony for bias motivated crime?
Madam Chairman, Representative Swanitzer, I would have to go back and look specifically to answer that question for you. I don't have a good answer as to what the common theme is.
Oh, they work now. Oh, great. County Attorney, Mr. Worrell, is he available?
Madam Chairman, he's not online.
Okay, great. So with that, I see Representative Sweeney is in the room. Representative Sweeney, please come forward. Representative Sweeney, do you have anyone with you?
Yes.
Sure. Come on forward, Mr. Shaver.
Thank you, Madam Chairman. And I don't know if Representative Conley is online.
She is not,
Okay.
according to staff. Do we have any other legislators in the room or online? Okay. Representative Sweeney, you are the one we're
Thank you.
acknowledging.
Wow.
Welcome,
So-
Representative Sweeney. If you'd introduce yourself to the committee, of course, we all know, but for members of the public, helpful to introduce yourself and Mr. Shaver, the same for you.
Thank you, Madam Chairman. My name's Pat Sweeney. I represent House District 58, which this is not a part of. But basically North Casper, Bar None, Edgerton, the airport, and a lot more antelope than people. So with that, thank you, Madam Chairman and committee. It is truly a privilege to join you for today's conversation on bias motivated crimes. And I thank you for considering this issue during the interim. I was pleased to sponsor House Bill 218 this past session and to have the support of 13 colleagues in the House and the Senate as co-sponsors. The House Judiciary Committee began an important conversation on this issue in March, and it is good to now include our Senate colleagues in the discussion. This is an issue that I passionately care about. And I moved to Wyoming in 1979 and from Pennsylvania. And I come from a portion of Pennsylvania that was part of the Underground Railroad. And my family have generated and instilled in me and have ancestors dating back to that time in right next to us where I grew up, an actual site of the Underground Railroad as the slaves were trying to migrate for freedom to the northern part of the country at that time in Canada. I also care passionately about this. I used to be in the hotel business. Now the Clarion was the Parkway Plaza Hotel. And during Matthew Shepard's funeral, Matthew and the Shepard family were from Casper. And during the service, we hosted at the hotel the family. And from that point forward, I wondered why we as Wyoming didn't have hate crime laws and more to the point of how do we get better? How in this day and age, fast forwarding from Matthew's funeral to today, 23 years later. So in the conversation of bias motivated crimes, they cause unique harms, both to individuals and to the entire community. When a perpetrator intentionally targets an individual for a crime, because of that person's actual or perceived identity, it not only harms the individual, but also harms the group of people who share that person's characteristics, as well as the community at large. It sends a message that they are not safe, that they are not welcome. And in the vast majority of these crimes, absent the victim's personal characteristics, no crime would have been committed at all. Because bias-motivated crimes cause unique and extraordinary harm, they require unique tools to respond to them. In recognition of this fact, the vast majority of the states have enacted bias-motivated crime laws. These laws not only have become the norm in virtually every state, but they are also broadly supported by a wide variety of religious, civil rights, and law enforcement organizations, including the International Association of Chiefs of Police and the National District Attorneys Association. Hate crime laws have a long history in the United States, as you heard from the research material. And I'll just touch on those. The first hate crime laws were passed after the Civil War, beginning with the Civil Rights Act of 1871 in order to combat the growing number of racially motivated crimes that were being committed by the Reconstruction era of the KKK. The modern era of hate crime legislation began in '68. Congress passed the Civil Rights Act in 1968 to address racial violence against African Americans and civil rights workers. In 1996, the Church Arson Prevention Act, the Hate Crime Statistics Act of 1990, Hate Crime Sentencing Enhancement Act of 1994, and then 2009, Matthew Shepard and James Byrd Jr. Hate Crime Prevention Act. In Wyoming today, if a Wyoming citizen were the victim of a violent crime, and that crime on its face was clearly intended to intimidate a person in their community, that victim would not be able to demand in a Wyoming court that justice under this fact. This does not intend to suggest that Wyoming's judicial system is weak on crime. Wyoming, we know, is tough on crime, and the current criminal statutes and sentencing guidelines are strong. However, if justice sought for the crime includes a statement that violence intended to send a message or intimidate a victim's community, and think about a church fire, and that victim would not have a remedy under our state law. Wyoming does not have a criminal statute that addresses the criminal behavior behind bias-motivated crimes. I believe it is important to clearly and specifically address this in Wyoming's criminal code. Some have argued that Wyoming does have a hate crime law, but I would argue that is not the case. Those statutes, 69, 101, and 102, address discrimination and civil infractions, not the type of criminal conduct that is associated with hate crimes. Moving bias-motivated crime legislation forward in Wyoming is an opportunity to affirm that Wyoming's law enforcement community, prosecutors, and judges are tough on these types of crime in Wyoming, and that state supports those people and communities who are most frequently targeted with these types of crimes. Finding a consensus on this issue will send a strong message, especially to the business community, which you'll hear from today, that Wyoming takes the issue of bias-motivated crime seriously and will hold offenders accountable for their actions. I look forward to working with all of you and the various stakeholders on this issue to pass a bias-motivated crimes law for Wyoming. Thank you, Madam Chairman.
Thank you, Representative Sweeney. Any discussion or questions for Representative Sweeney? All right, seeing none, Representative Sweeney, if you'd like to introduce who you're with at the table.
So committee and Madam Chairman, thank you. Jeremy Shaver is the Senior Associate Regional Director with the Anti-Defamation League. He's based out of Denver, and that office covers Colorado, New Mexico, and Wyoming. And he's been instrumental in helping us craft and work on the issues, both for and against. And with that, with your permission, I really appreciate, he's definitely the one to ask questions, not me, if you want the right answer. So with that, Madam Chairman.
Welcome, Mr. Shaver. If you would introduce yourself to the committee, even though Representative Sweeney did, that'd be helpful. And please share with us your comments.
Great. Thank you, Madam Chair and Mr. Chair and committee members. It's a pleasure to be with you all. It's good to get out of my home state and come to the jewel of our ADL Mountain States region here in Wyoming. Our region does have 515 supporting members here, and Pathfinder High School in Lander was a school that successfully completed our No Place for Hate program this year. So we're always excited when we get to work with our community in Wyoming. So as Mr. Representative Sweeney mentioned, ADL has been involved in this work for many years. ADL drafted the model bias motivated crime statute in 1981 that many, if not most states now use as the basis for their bias motivated crime statutes. And I think I just wanted to focus on two issues, if that's okay. I think one is looking at why are bias motivated crime laws important, and particularly important to us? And the second, again, is why do we believe Wyoming needs one, or answering the question, does Wyoming have one? So I think looking at that first question, why are bias motivated crimes laws necessary and important? It gets to a couple of real key points. I think one is that the criminal activity motivated by bias is distinct and different than your everyday run-of-the-mill criminal conduct. And so we say that bias motivated crimes are unique with unique harms. And so we're looking at when somebody is intentionally targeted because of who they are. So somebody targets somebody, an aggressor targets somebody because of their own personal bias or animus against somebody else. That is different than your standard assault or vandalism. And so what that gets to is there are four primary elements to bias motivated crimes laws. And this does kind of help answer whether Wyoming does or does not have that. But how we look at that and how the model statute was written is that you have the nature of the act and then the motivation of the act. On the nature of the act, there's two key elements. The first is the criminal conduct or criminal activity. That could be assault, vandalism, harassment. And no one is charged solely with a bias motivated crime. You always have to have the underlying offense, the vandalism, the assault, right? So that's the first element, the criminal conduct. The second is that persons or property have to be impacted. So a person targeted or property damaged. So that's the nature of the act and those first two elements. The second part is the motivation of the act, and the third and fourth elements that are key to hate crimes laws. And so the first is the intentionality of the act. That is what makes these types of crimes different from other types of crimes, right? Is that you have to demonstrate the motivation or the intent. And so there's somebody intentionally targeted, and then because of their identity. And so that's the final element, somebody's actual or perceived identity. Anyone can be targeted for a bias motivated crime law. We all have a racial identity. Most of the bias motivated crimes conducted that are committed each year are based on a racial or ethnic bias. When we look at religion, the vast majority are based on an anti-Jewish bias and target the Jewish community, which ADL works on behalf. But there are also anti-Catholic crimes targeting individuals because of their disability. They find that lacking because it doesn't have all four of those elements. I think it also is instructive from the memo from LSO that we do not actually see that being used to prosecute these types of crimes right now. So it would be probably important to dig into that a little bit as well. And I think it's also important to note, some have argued, well, there's the federal law. Why do we need a state law? And I think it's just very critical to share that the federal law was never meant to supplant the state laws. And in many cases, the federal law can't address the type of crimes that we see happening: property damage, vandalism, harassment. So that's also really important. I guess at the end of the day, what I hope to argue with you all is that what we want to see, what would be helpful to see in Wyoming and any state that we're working on these types of laws, is something that gets to the real crimes that we see intentionally targeting individuals because of their identity. The assault, for instance, assaults against members of the Black community or individuals because of their religious identity. We're really trying to get to that very specific type of criminal conduct. And then the last comment I'll share is that I do appreciate that there's been quite a bit of conversation about reporting and the importance for reporting. And I do think that is a key element of a good bias motivated crimes law. You cannot address something that you cannot measure, right? And so data is important, and it's absolutely critical to be able to look at trends and see what's happening in a community. In some ways, that data can help build some trust between law enforcement and targeted communities because there's some level of transparency to see what's happening. But I don't think reporting is enough. Reporting isn't enough to address bias motivated crimes, which are message crimes. The messages behind these types of crimes, when somebody intentionally targets somebody, the message is, you are less than, you are not welcome here, be afraid, we don't like you, we're better than you. And so these types of crimes provide that countervailing message to say, no, we will not allow our social fabric to be torn by these types of things that intimidate and harass communities, individuals who also share the identity of a target, and the community at large. So with that, again, I'm just very appreciative of your time and your consideration. And I did bring another just summary chart that ADL has put together. I do note that the research memo provided by LSO has much of the same information, and maybe even took some of it from this chart, but ADL, and I know the one by Sabrina King also looks at this, but I did bring it. It shows the statutory reference for each state, which protected classes are in each state law, whether the state includes a civil action, data collection requirement, police training, and then there's totals at the bottom to show you how many states have which pieces. So I just provide this as a supplement to the other great resources that you've already received. So thank you.
Thank you, Mr. Shaver. Appreciate hearing from you. Questions for Representative Sweeney or Mr. Shaver? Representative Yan.
Thank you, Madam Chairman. Mr. Shaver, do you think states that have had penalty enhancements versus individual offenses, which one has been more effective, or what is considered a best practice, or is it just all over the place based on
Mr. Shaver?
states choose?
Thank you, Madam Chair, and thank you, Representative, for the question. I don't necessarily want to get into the business of making value judgments on the state laws, but I do think you've already heard that there are three general approaches, right? One is to have a standalone statute. One is to have a penalty enhancement statute that prescribes, for instance, in Colorado, under our bias motivated harassment statute, a class 3 misdemeanor is automatically escalated to a class 1, and that's the penalty enhancement there. So it can be prescribed in that way. And other states look at it as aggravated factors at sentencing and allow for that to be considered to see what was happening then, and then an individual may face a stiffer penalty because, again, of the nature and that intentionality of the act. So I think any of those three approaches have their merits, as probably maybe some of their demerits as well. But I think those are the three common ways to get to it. And I think any approach would be a step forward. Does that help?
Any additional questions for Mr. Shaver? Representative Provenza.
Thank you, Madam Chairwoman. And thank you for being here today. My question, and this will kind of allude to in my email that I sent to LSO about the table that we had, where Minnesota is listed as having covers hate crimes in which victim targeted because of, and all of these are listed. And what I did when I sent LSO an email, I put in Minnesota's, and I was asking what's the threshold, like why were these categories checked for this state versus another? Because when you look at Minnesota's laws, and which it looks like the Anti-Defamation League has also identified, what Minnesota says is assaults motivated by bias have whoever assaults another because of the victim's or another's actual or perceived race, color, religion, sex, sexual orientation, disability as defined in this section, age or national origin, may be sentenced to imprisonment for not more than 1 year or to payment of a fine of not more than $3,000 or both. That language, specifically the may be sentenced to imprisonment for not more than, is identical to Wyoming statute, other than this change that is made in our statute would be for not more than 6 months and $750 or both. So it's a lesser penalty, right? And so I'm wondering, how do we, with the law that we have, 69102, how do we get that to come to the threshold of what, you know, the pillars that you brought?
Mhm.
And is that going to be enough to stop hate crime, or to maybe not stop it, but to keep people from being victimized by bias incidents?
Mr. Shaver.
Thank you, Madam Chair, and thank you, Representative, for the question. I think what I would like to focus is to say that, again, when we look at the four elements that are common to hate crimes laws, and that we do see as the standard, that 69102 does not meet all four of those elements. And I think there are other ways that statute would be lacking. For instance, there's some very critical, important classes, protected classes, that are missing from that. There is not a reporting requirement. There's not a training requirement. So I think it would be inadequate in a number of areas. So I think if there would be a way to again focus on the underlying criminal offenses, and looking at what are those offenses that are most commonly committed against individuals because of their race, their religion, their ethnicity, their sexual orientation, which again is the assault and such. I think it would be really helpful to understand from our prosecutors also why that statute's not being used currently. So I think what you're getting to, and what I would agree with you, is that there are some inadequacies to that existing statute, and it would be important to address those in whatever manner is decided, by this committee to move forward with that. But there are some inadequacies.
Senator French.
Thank you, Madam Chair. Do you have, sir, numbers for Wyoming on, as far as quote hate crimes for sexual orientation, all the race, religion, all the things, the gender? Do you have numbers? Is there 20 race hate crimes in the state, 10, 5? Do you have numbers for all these categories?
Mr. Shaver, and for a little bit of help, the LSO memo does have some of that information on page 3.
Certainly. So thank you, Madam Chair, and thank you, Senator French, for the question. I think it's important to note that there are 3 primary sources of data on bias crimes in the United States, and there's probably an additional source here in Wyoming. We have to look at the FBI report. We look at the Department of Education and the types of bias crimes that are reported to the Department of Education, and then the types of crimes that are also reported to entities that track what's happening on college campuses. So certainly Wyoming DCI, collects data for you all, but I think, again, the research memo did do a very great job of highlighting so many different issues, and it did point out that even without a bias-motivated crimes statute in Wyoming, there were some agencies that chose to pass along data to the FBI, which we commend those agencies for doing so. And there were 5 different agencies that reported 5 different bias crimes in 2019, which is the most recent UCR available. 4 were race-based, ethnicity-based, if I'm not mistaken, and 1 was sexual orientation-based. What I do want to just be careful, however, to note that in the absence of a statute, that data is not full, it's not accurate, and it's lacking. And it's also important, there are so many reasons why underreporting is actually a problem that persists with bias-motivated crimes. The crime victim survey that was mentioned earlier, the most recent study there in surveying crime victims found that about 50% of bias motivated crimes go unreported. So there's a variety of reasons for non-reporting, and I think again that's important to consider. But those are some of the data points that are available for Wyoming.
Follow up, Senator French.
Thanks, Madam Chair. Do you have statistics as far as what you're just talking about, unreported or afraid to report, whatever, for whatever reason, versus if a enhancement law is passed, the reporting, the unreported there? It is, how does it change that? Or
Mr. Shaver.
Thank you, Madam Chair, and thank you, Senator, for the question. I do not believe there is any data or research that exists that answers that specific question about what is the impact of passing a hate crime and how does reporting improve. So I do not have anything that I can specifically provide to you on that, Senator, but I can look to see if something exists, but I'm not aware of any research or data on that particular question.
Representative Yen.
Madam Chair, Mr. Schaefer, thank you. Maybe to reframe the question a little bit. So one type of law that gets passed is a reporting requirement, essentially, because right now we don't have a reporting requirement. So as far as I know, I think it's voluntary entry in the UCR for any hate crimes. Does a reporting requirement, has anyone tracked the stats in the UCR from before a state has implemented a reporting requirement to after a state has implemented a reporting requirement?
Mr. Shaver, if you know.
Thank you, Madam Chair. It's an important question and one that I am not able to answer to you today, but I'm certainly willing to look into it and see if I can find something. I do just want to add one very slight side note and just to point out that when we talk about reporting happens two different ways, right? It happens both from law enforcement saying we have received this number of incidents and we're passing that along, but it also happens from those communities that are most frequently targeted with these crimes. And so there's a lot of dynamics at play in reporting, and it's important to look at, how to build trust and transparency between affected communities and law enforcement to improve reporting, and what are the right reporting channels. I think there is some study and research happening right now about why or why not individuals may not come to law enforcement, and I don't have that to present to you now because I'm actually doing something currently on that, but I'll see if I can find something else to answer this question. And if so, I'll make sure to send it through Representative Sweetie and get it to you all, but I don't have that for you.
Representative Rodriguez Williams.
Thank you, Madam Chair. Sir, do you know of any data or research that exists that supports the notion that hate crime legislation may cause reverse discrimination?
Mr. Shaver.
Thank you, Madam Chair, and thank you, Representative, for the question. Is there research? If there is, I'm not aware of it, but I think it's important to note that is a misconception of bias motivated crimes laws, that they result in some type of criminalization for somebody's belief or their opinion. I think it's really critical to note that bias motivated crimes laws do not impact speech. Hate speech is constitutionally protected in the United States. Bias motivated crimes laws do not protect or do not impact an individual's ability to hold deeply personal religious beliefs and to speak them from the pulpit. There are very strong protections for religious freedom protections when it comes to these types of criminal statutes. They do not impact speech whatsoever. What we're talking about here is when somebody crosses the line from believing something into actually actively committing a crime, arson, assault, vandalism, and harming another person. That's the line. So speech, belief, opinion, those are not crimes, and those are not impacted by this statute, these types of statutes at all. They're actually very strong protections. There was a Supreme Court decision in 1993, Wisconsin v. Mitchell, that was a unanimous decision. Chief Justice William Rehnquist wrote the opinion in that and said that bias motivated crime laws, by having that penalty enhancement, do not impact speech and individuals' ability to hold speech. So I think that's just important to note that is one misconception, I believe, of these types of laws.
Any further questions? We do have more public comment. So Representative Sweeney, we'll give you one last bite at the apple, okay, when we're all finished. let's try to get through some of these, but do you have a quick comment? Quick.
Yes, thank you, Madam Chairman. And to the previous issue on reporting, I think that's important to note that whatever comes out of this, that some people just aren't really comfortable to report to a police or a law enforcement officer for whatever reason. So if we can include something, and I don't know what that looks like, but I know there's plenty of smart attorneys in the room that could come up with that. But I think that's important. I think that's important. And with that, I really appreciate your attention to this, and hopefully we can craft something that's meaningful for Wyoming.
Thank you, Representative Sweeney. I think we've been joined by another legislator who we always acknowledge first. Representative Connolly is, I think, in the Zoom room. Nope. Right. Well, I hear she's watching. Hello, Representative Connolly. Glad to know that you're watching. All right. And no need to appear on Zoom if you don't need to. I just heard that you might be there, so wanted to make sure you were called on. All right. Thank you so much, both of you. With that, we'll turn to public comment. Ms. King, you have been mentioned a number of times and provided us some materials, and no one wrote extensively on this. Welcome. Please introduce yourself to the committee and share with us your thoughts.
Thank you, Madam Chairwoman and members of the committee. My name is Sabrina King, and I am representing the ACLU of Wyoming today. Actually wasn't planning on talking very much about hate crimes in general, and spending a little bit more time talking about reporting, which I think is actually the more interesting part. But just to address some of the issues and the questions that have come up, I have, for better or for worse, read every single state's hate crime law. And so I speak with some confidence here to say that every state handles them wildly differently. So I do want to push back a little bit on the idea that there is sort of a standard way of dealing with hate crimes. From my reading, there are a small handful of states that actually have, all four elements that were discussed by the previous presenter. And frankly, the vast majority of states in their laws don't actually call them hate crimes. They don't define hate crimes, nor do they reference bias. So I'll give a couple of examples in a minute, but just to kind of address the fundamental question. And I do think this is important because I do think it impacts how we move forward in this conversation and what we decide to draft, if anything. And as I sent to the committee and as is online, the automatic sentence enhancement piece is actually done by only 20 states. So 20 states have an automatic sentence enhancement. Every state does that differently. Some states add time or add a penalty. Some states bump the crime from the lower level crime to the higher level crime, as was mentioned. The second category is the separate crime statute, which is what Wyoming has. And again, every state does this differently. And again, very few of those that are categorized as hate crime statutes actually mention hate in any way. Just a couple of examples. In West Virginia, their hate crime statute is prohibiting violations of an individual's civil rights. And it is actually rather narrowly tailored. In Michigan and in several other states, the title of the statute is actually ethnic intimidation. And there are many states that deal specifically with intimidation or harassment, which I think is actually, I think it's quite interesting, all of the different ways that states have decided to handle this. And as was mentioned before, Minnesota, their law is assaults motivated by bias. So that is the only actual crime, but it is a standalone statute. I think I just closed my sheet. The third piece is when you are looking at a bias motivation as an aggravating factor. And what I think is actually really interesting is if you look at the bill that was presented to the legislature this past year, it was House Bill 218. That bill, what it does is it actually created a potential alternate sentence or an alternate penalty that could be, I mean, it was community service, treatment, education, that could be given in addition to the underlying penalty for whatever the crime was. And then the bill sort of, I think in a somewhat convoluted way, but it actually just created, it made hate crime an aggravating factor that should be considered in sentencing. So the bill says the court shall consider whether a crime was a bias motivated crime as a factor during sentencing. So the bill that was presented to the House doesn't actually create an automatic penalty, sentence enhancement, or a new crime. So just an interesting note about what was even presented to the legislature this past year. Just to kind of close this piece out, I think just to really give a scope of the variety of ways that states handle bias crimes, in Hawaii and Tennessee, the sentence enhancement is optional, but not mandatory. In every other state where there's a sentence enhancement, it is mandatory, but in those two states, it's not. In Kentucky, a finding of hate or bias motivation can only be used to deny probation, parole, or conditional release. So it's not even actually considered a separate crime. It is simply, used as a denial of probation or parole. In Iowa, there's no criminal penalty. There's just a civil remedy. And in Connecticut, there's no jail time for it, only a fine. 3 states, rather than enhanced sentenced, provide for alternative penalties such as community service, like ours did. So something else I think that is an interesting component of some hate crimes laws, but was a component of what was given to Wyoming's legislature as our hate crimes, our potential hate crime statute. So I do think it matters, and I do think in the context of this discussion, and as we really move forward, I think it's important to acknowledge that Wyoming does have a hate crime statute in 69102 under sort of this second way of going about hate crimes, which is you are actually looking at a separate crime. If we want to change that, then that is up to the legislature, but I do think it is important to acknowledge that. And it is, I will also say it's not just me and the ACLU saying this. The Congressional Research Service and the Human Rights Campaign and others, so just, I guess, depending on who you ask, Wyoming does or does not have a hate crime statute. But when you really actually look at what every state is doing, Wyoming is right there along with them. So what I do think is genuinely the more interesting piece of this, and where I do think there's maybe some commonality amongst all the groups, including the ACLU, is the reporting mechanism. So as has been discussed, there's not mandatory reporting in the state of Wyoming. Law enforcement does have a mechanism already in place to be able to report bias and hate crimes, as has been discussed. DCI compiles that information, they send it to the FBI. I think it would be helpful for this committee, and honestly, I think for those of us who are advocating on this issue, to better understand how law enforcement across the state of Wyoming is addressing bias crime right now. From what I've seen in the DCI reports, there are agencies that consistently report bias crimes, and there are agencies that report bias crimes maybe once every 5 years, or report that a bias crime has happened. So I would be curious to understand better from law enforcement and from the agencies who are actually doing this work on the ground. What does their training look like now? How do they consider something a bias crime? Because it's clearly already happening. It's just not happening consistently. So I think one of the questions is, how do we address consistency in our reporting of bias crimes? And do we need to change statute in order to do that? Or do we just need to, talk about standards and ensuring that is actually being done? One of the other documents that I sent to the committee earlier today does have a sampling of how various states handle reporting. And again, it is incredibly varied. Some states have very detailed laws regarding reporting, how it's done, where it's given. where the reports are given, you know, and then on the other end, you have a state like New Mexico, which really just says law enforcement will report hate crimes in accordance with the guidelines under the Federal Hate Crime Statistics Act. So, I mean, if we need to make it mandatory, that may be a direction to go. The state that I find it most interesting in terms of their hate crimes law, and one that I think that we should perhaps examine, is Utah's. And their statute addresses compiling statistics concerning crimes exhibiting prejudice, and they list the different prejudices. They also, in that same statute, require statistics concerning use of force by law enforcement officers in accordance with the FBI's standards. So there are, again, many different ways of handling the reporting issue. I think it would be helpful to understand how law enforcement agencies are doing this now, before we maybe move forward with drafting. One other issue is this question of, can we create some sort of alternate avenue for reporting of hate crimes for those folks in those communities who may not necessarily want to first go to law enforcement. There may be some ways to do this, perhaps through, perhaps through the Attorney General's office. I'm not exactly sure what that mechanism would look like, but it does seem like there are potentially similar ways that this is done for domestic abuse. So we could maybe look at those statutes. I'm thinking in particular of 720-107. So I think there's some potential there. But fundamentally, when it comes down to the reporting of hate crimes, I do think that is going to come through law enforcement. We do need to address, if there are issues of, if there are issues between communities and law enforcement so that these crimes aren't being reported, then that's something that needs to be taken care of regardless, right? So however we can sort of enhance those relationships to make sure that crimes are being reported, that is helpful. I think I've covered everything, actually. Yeah.
Representative Washut.
Thank you, Madam Chair. Mr. King, thank you for being here. I found your testimony quite interesting. But my question has to do with finding the gaps in the data. Yesterday, we heard a lot of testimony about a group called Council of State Governments that might be able to come into Wyoming and do a study to find gaps in our juvenile crime data and juvenile process data. Are there organizations that do formal comprehensive studies of a state like Wyoming to try and find the kinds of gaps in reporting and perhaps data that exists, but we don't have it at our fingertips?
Yeah. Madam Chairwoman, Representative Washut, I am not specifically aware of organizations that do that. I do know, and this is perhaps actually a better question for the previous testifier, but I know Colorado is going through a process right now where they're studying that exact issue. I don't have the details of how they're doing that or who exactly is in charge of that process. I think they have a governmental committee that is doing that work, but I am not 100% sure on that.
Representative Zwanitzer.
Thanks, Madam Chairman. Here's my concern, Sabrina. I can't seem to pin you down where the ACLU is on this issue, because this is good and this is bad. And can I get it in 3 sentences or less? The ACLU perspective. Obviously, you're very much into hate crimes legislation, but it's good sometimes and bad sometimes. I just want the overarching philosophy of what you're pushing to the legislature so I can kind of pin you down and go from there.
Ms. King, are you pushing anything? I'm not aware, but
Representative Zwanitzer, yes, this is a complicated issue, and it is difficult because there are many components of it. So fundamentally, I would say we do not support automatic sentence enhancements. We do not believe we need to create a new statute creating a new crime as that already exists. So on that front, we do oppose that. We do support better reporting. It is our position that in all likelihood can be done without any statutory changes. But I think we need to better understand how reporting is being done now in order to fully understand if we are actually in a position where we need to create a new law.
Senator Kolb.
Thank you, Co-Chair Nethercott. Hi, hope you're having fun.
Always.
I am confused about the difference in the way people are using words. Hate crimes and bias motivated crimes. I mean, I'm assuming they're the same thing said a different way.
Senator Chairwoman Nethercott and Senator Kolb, I frankly sometimes have the same question. I think both terms are used. I know that under the Department of Justice, the definition is as a hate crime. And so the definition of a hate crime is a crime motivated by bias against race, color, religion, national origin, sexual orientation, gender identity, or disability. So in terms of federal reporting, hate crime is the term that is used. Some states use bias crime, and the bill that was presented to the House Judiciary Committee was a bias crime reporting bill. So I am not sure why one term is used in any given moment or another. And I don't know why the 2021 bill was a bias motivated crime bill. So I sometimes have the same question.
Follow up. Next, there's 5 hate crime or bias motivated crimes, hate crimes, whatever we're going to call them, in 2019, reported by DCI in Wyoming. So my big question is this: I tend to believe that, frankly, all crime is bias motivated. You know, someone sees somebody they think is a victim, whatever, for whatever reason, it's bias motivated. I think we're just trying to put it in a separate category now or identify it differently. And I'll tell you up front, reporting, getting data that we already have, I see no issue with that. And so I just want to throw it out there. Why isn't all crime bias motivated? And I'd like to hear your answer to that. Thank you.
And we'll pose that question to anyone who wants to provide public comment as well. So it's not, that burden is not solely on Ms. King's shoulders.
Thank you, Madam Chair. And Senator Kolb, I mean, I do think this is also a common question. I do think part of why hate crimes or bias motivated crimes bills are brought, why there are separate statutes and federal laws, because there have been and are groups who are specifically targeted because of their identity. And so parsing that out from someone who commits a crime because they simply want, they want to engage in theft or whatever else. I do think that there is a difference. But again, I probably am not the person to really comprehensively ask that. I think there are a lot of different reasons that people want to pull out hate crime as a separate issue.
Representative Yin.
Thank you, Madam Chair. Ms. King, would you consider a speeding violation a bias motivated crime? Or if I break into someone's car that I've never seen before and steal their purse, is that a bias motivated crime?
Madam Chairwoman, Representative Yin, I don't think I would be able to say. I mean, I think that is the thing that you have to figure out when you actually look at the crime. That is the job of law enforcement, and potentially, depending on how the statute's written, the prosecutor and the judge to determine.
Ms. King, thank you. We have other public comment, so you don't need to come up with questions, but if you have them, that's great. Co-Chairman Olson.
Yeah, no, I do. I'm just patiently waiting. Okay, so on the actual subject, which is crime reporting, I'm hoping you'll be able to help me with this, because it looks like, I mean, your research into these statutes may be deep enough. So particularly curious about the data collection statutes, and so when I look at the ADL spreadsheet, for example, it just shows me when states have a statute across all 4 categories. I'm just curious if you can have a true data collection statute without, for example, police training. In my mind, maybe they go together, that's part of the input, the data input into the system that you need police training. But then I find an asterisk on the spreadsheet that tells me that Texas doesn't have police training, it actually just trains prosecutors. So then I think about that and how, well, if you're entering the data, you certainly need to be able to identify it. So police training and prosecutorial training seems really important. And I'm just curious if if in your research, data collection statutes can stand alone. Do they need police training? And then to take it one more level, like the ADL spreadsheet does, can you have a true effective data collection statute without a properly defined hate crime to know what you're identifying, what those who are trained are now identifying and putting into the system?
Yeah.
Ms. King.
Madam Chair, and Chairman Olson. So I think one of the interesting components of some of these laws is that in a few states, Texas may be one of them, but they do specifically state, whether the crime is determined to be a hate crime at the prosecutorial level versus by law enforcement. Law enforcement still has to make some determination in their reporting to the FBI, right? So in the Uniform Crime Reporting System, law enforcement is making that determination. And I have had a couple of conversations with law enforcement about how they do that reporting. I am hopeful that there are some other law enforcement folks who might be able to speak to this better than I can. But they do get training on the UCR system. They're transitioning to a different system. They will be trained on that. I have actually read the training for hate crime reporting that exists from the FBI. And so there is training that already exists for law enforcement. Some states, the additional training is for law enforcement to, sometimes it's specific training for law enforcement on how to identify a hate crime. Sometimes it's training on mitigating hate crimes. So when states have specific training statutes, they vary in terms of who they're training. If they have to train the prosecutor, they'll train the prosecutors. If it's law enforcement, they're training them on different things. But when it comes to just the basic reporting, law enforcement does get that training because they get that training when they use the system, basically.
So in summary, you can have, Wyoming could have just a data collection statute because the
Yes.
training is already there.
One component, and this may come from, it may come from the Anti-Defamation League. I don't know where specifically this comes from, but in many statutes for the reporting, there is a particular sentence that is used, and it says that, whatever the agency is, so whether it's, here it would be DCI, I assume, shall collect information concerning criminal offenses that manifest evidence of prejudice based on race, color, religion, national origin, sexual orientation, gender identity, and disability. So you can, I think you can specify for the agency that is gathering statistics and for law enforcement agencies that they need to collect information concerning criminal offenses manifesting evidence of prejudice, which is usually how it's phrased in other states. So I think there is the possibility to do that. Yes.
Just one follow-up, Madam Chairman.
Follow up.
I think you said Utah law was a curious one to look at, but that would be my question to you then. What if I wanted to find a good example of a data collection statute as a good first step for Wyoming? Is that where I would look, or would you select some other states, or where would I look?
Madam Chairman and Chairman Olson, I would start with Utah. Theirs is relatively recent. And so I think, just on that note alone, I think they've looked at a couple of different components. I also pulled out Michigan, which has very similar language. In Arizona also, I think has very similar language. So for a simple statute that is directly addressing hate crime statistics reporting, making that mandatory, those would be the places that I would start.
Thank you.
Final questions for Ms. King? This will be the last question, and then we're going to move on. Representative Provenza.
Thank you, Madam Chairwoman. And Ms. King, this question may be better answered by members of law enforcement, and hopefully I'm summoning my chief of police because I've had this conversation with him kind of previously, and so I'm wondering, you mentioned that law enforcement can't get federal grants, I guess, through, is it the hate crime legislation that passed in the 90s if they don't report? Is that correct? And do you happen to know if there are any different municipal or state nuances there that allow for bias reporting that isn't necessarily falling under maybe 69102 or otherwise? So is the federal grant money that comes from the federal government contingent on that law enforcement participates in the UCR, and how much?
Madam Chair, Representative Provenza, I am not 100% sure on that question. I do know that when law enforcement uses the FBI's reporting system, which DCI does, they do have to report on all of those components. So the question is whether or not, law enforcement is really looking for the hate crimes or the bias motivated crimes. I do know that with the most recent hate crimes legislation passed in Congress and just with ongoing funding, there are federal resources available for law enforcement agencies to get more training regarding hate crimes. And I do, I have had the same conversation, I think, and I do know that at least one, if not, I think multiple agencies in the state of Wyoming have actually done it sort of, I guess, advanced trainings on identifying and reporting bias crimes. So I know that is also happening in the state.
All right, thank you, Ms. King, appreciate you. We do have Kara Chambers from the Attorney General's office. Ms. Chambers?
Good afternoon.
Welcome, Ms. Chambers. It's great to see you. And I know I called on you, but we do have an agency head here. And I know that there was a question regarding some of the compilation of data. Ms. King provided us a handout referencing statute 71102 Wyoming statute, which is a record of information for ascertaining condition of crime in the state. Do you happen to have a copy of that?
Madam Chairman, not in front of me, but I believe that's the general authorizing statute for our Wyoming criminal justice information system.
It is, Ms. Chambers. And one question I have for
I
you.
can probably pull it up if you talk slowly.
I will talk slow. The statute authorizes or directs the Attorney General that the Attorney General shall provide forms for the reporting of all information necessary to obtain reliable statistics to ascertain the true condition of the crime situation in the state. Are you aware, has the Attorney General's office or through the governor asked for crime statistics associated with bias crimes or hate crimes?
Madam Chair, let me step back a moment. My name is Kara Chambers. I am the Director of the Division of Victim Services within the Wyoming Attorney General's office. I also serve as the Attorney General's legislative liaison, so I'm kind of wearing a couple hats right now. Right now, I'm going to answer sort of on behalf of DCI. Yes, so the statute go ahead.
Ms. Chambers, I'm going to give you a minute and we're going to take a quick recess.
Sure.
Thank you.
Even better.
Committee, we're taking a 5-minute recess. We'll come back in 5. All right, I think that was a good timing on a bathroom break. And as we come back and in the spirit of this particular agenda item and topic for the day, it is Representative Oakley's birthday. And so being concerned about ageism and bias and where that's going, we figured we'd just make sure we all got to sing happy birthday to Amber Oakley. That's right. That's right. Get you used to it. So ready, everyone together? All right, so with that, we'll formally come back to order. Ms. Chambers, welcome back again. If you would introduce yourself to the committee, and we're on 71102.
Yes, thank you, Madam Chair. My name is Kara Chambers. I am the Director of the Division of Victim Services within the Attorney General's office, and I also serve as the Attorney General's Legislative Liaison. And as a reminder for some of the newer members, the Attorney General's office is the umbrella agency for not only the law office, which I think most people think of, but also the Division of Criminal Investigation, DCI, the Wyoming Law Enforcement Academy, Post Commission, which is the professional licensing entity for law enforcement, and the Division of Victim Services. So I wear a few hats. Back to the statute, which is again that authorizing statute for the Attorney General's DCI. They do have a form, and to hearken back to some of the testimony that you heard yesterday with regard to juvenile justice, you probably heard about YCJUS and, well, actually maybe even some of the testimony from this morning about, court automation and connections. So the courts through the Supreme Court and DCI do interface with their data. And so they have developed various reporting forms and mechanisms for law enforcement to report data, both arrest data and disposition data. And so one thing that I wanted to comment on is maybe some of the questions that Ms. King received as far as like training law enforcement. So you would have one record of arrests and you would have a separate record for a disposition, or whether that arrest even resulted in a disposition. And so I don't want to get too in the weeds. I know you have a lot of testimony, but yes, and maybe because of the break, I've forgotten your specific question about the statute, other than yes, we do have a mechanism, and that's essentially what DCI does. It's created this form to collect various data points.
Yeah, Ms. Chambers, so the question really is, do you know if the governor has directed the Attorney General or the Attorney General herself to make it a priority to obtain information or reliable statistics per the statute? Because the statute uniquely says this: the Attorney General shall provide uniform forms for reporting all information necessary to obtain reliable statistics to ascertain the true condition of the crime situation in the state. And so, in order to ascertain the true condition of the crime situation in the state, what is that? How do we do that? Clearly, there's a question concerning bias motivated crimes and those particular issues associated with hate crimes or those against protected classes. Has that effort been undertaken or been directed by the Attorney General? It doesn't look like additional legislation would arguably even be needed if the Attorney General perhaps made this a priority or ordered it to the law enforcement agencies or the governor, either one being in that position of authority.
Madam Chair, it is a priority, and it has always been a priority. And in compliance with federal law, the Division of Criminal Investigation has created the Wyoming Criminal Justice Information System, where we collect criminal justice information to report into UCR, which is now going to transition to the NIBARS, the National Incident-Based Reporting System. I may have garbled that acronym. And so, yes, it is a priority. And that's how they generate the Crime in Wyoming report. Now, perhaps what we're glossing over is, or maybe to your direct question is, do me sitting here personally think that we need a new statute? Not necessarily. We have statutes that require reporting of all crime. but there's not a lot of teeth to it. And what I have found, and again, I'm kind of going to go back to what I know quite well is domestic violence statistics. When I look at our specific domestic violence report in Wyoming that's compiled by DCI, there are agencies that simply don't report. They don't turn over data. And the concern that I have heard from DCI and my counterparts there is that we don't have a lot of teeth. We have a statute that says we'll do this, but I think it goes back to that funding question. You know, when we don't have that carrot and stick, so to speak, it is hard. And we do have, similar to your district court conversation, we have sort of these, each county entity run by a sheriff or an appointed chief, and they all kind of do their own thing. And that's maybe the Wyoming way, but it is tricky to compel compliance and to compel data collection. I've heard anecdotally, I won't call out the county, but that NIBARS is too complicated. I don't want to report into it. And it's not a small county, you know, and that's a problem. That's a problem for my agency as a whole, because I don't know that we have you know, hand on Bible say I have an accurate report of crime in Wyoming. Because if we're not getting the data, you know, garbage in, garbage out, so to speak. I mean, I don't think we get comprehensive data. Now, bias crimes in particular, obviously we're, you know, I could be a cynic and say, I'm surprised we got 5 reports because we don't, you know, necessarily put an emphasis on that, I guess, perhaps. I think we all understand it and there's federal requirements, but, you know, it's multi-layered. It's not just, I mean, law enforcement, I've spoken to the director of the academy. They do train on hate crimes. A concern with last session's bill draft was what was the intent of that? Was there to be specialized, additional? Was there something specific that was requested and required? And if so, what is that? And then it goes to prosecutors who would, you know, whether or not we have a separate statute that says, you know, this is a hate crime or this isn't or whatever. Maybe a prosecutor would have the training and discretion to say, well, this was clearly an underlying factor or a motivating factor. And that could be, you know, whether you look at penalty enhancements versus a standalone crime or what have you. I mean, a lot of this, I'm just trying to provide as information as to things that you need to consider. And then, you know, getting back to victim services, this whole measuring unreported crime is very hard. It's very hard to measure things that aren't reported. And so, you know, do we know this anecdotally that this occurs? Sure. I've one part of my division's job is that we have the Crime Victims Compensation Program. And I know of a case in particular where the victim was adamant that they were targeted because of their religion. And they were, you know, repeatedly told that Wyoming doesn't have a hate crime statute and why is this? And they were very frustrated. And why didn't the officer take this into consideration? And why aren't there other, you know, and it was just sort of, so, I mean, I know there are instances that officially I'm not recording because I don't have data on that. And if I realize this is, I'd be speaking to the House members now, if you recall from my testimony during session, one of the things that my agency, my division, excuse me, Victim Services is required to do as a recipient of our Department of Justice grants is report not just on crime data as far as crime types, but there are 5 victimization elements that we're asked about as well. And hate crime is one of them. The other being elder abuse, family, domestic violence, bullying, and mass violence are the 5. But I have never checked the hate crime box because I don't feel that I have enough information to do so. I do get the police reports, but I only get what's mentioned in there. You know, I'm not on the scene. I don't have all the information from the parties. And so, you know, from just that perspective, Victim Services isn't providing hate crime data because I don't feel that I have the appropriate mechanism or tools to do so. Meaning I don't have a statutory requirement that, does that make sense? That we're just not collecting the data the right way, I think, in that respect.
Questions for Co-Chairman Olson?
Yeah, you can go ahead, Senator.
Co-Chairman Olson.
Okay, all right. on that last little piece there. Not, I think you said, just not necessarily required to do it. Maybe if that requirement existed, maybe individuals would invest more time in figuring out, wow, do I check this box? And I'm just looking at, in comparing our statute that we're looking at on reporting generally that we've been talking about to the Utah code that we referenced earlier. There's nothing magical about the Utah code. It's the exact same statute that we have. It just delineates, it lists out everything you've been talking about that the FBI already requires as part of that grant reporting on. And so I just wonder if, and I guess Senator Nethercott's point is there too. Well, it's there inside the statute. The Attorney General's office could make it a priority and request these areas be reported on. Do you feel like if we were to just modify that existing statute to delineate, for example, the different data that we want reported, would that help at all?
Ms. Chambers?
Madam Chair, Co-Chairman Olson, I do believe it would help. One of the things, again, I'm not talking bias specific, but my wheelhouse is of domestic violence. One concern and one thing we are working with the University of Wyoming Survey and Analysis Center on is trying to get accurate domestic violence data and conviction data. And it really did come down. I know Ms. Butler is still here as we were talking about the court abstract about just having, it is sort of a matter of having that box to check. Do you think that this crime was a bias motivated crime? Or, in this, my instance, was this a domestic violence crime? Because there are certain crimes that, don't necessarily read as domestic violence or hate crime. Again, if this is the sentence enhancement, the assault is an assault is an assault, but they're not all the same. They're not all motivated the same. I mean, we could have an assault that's a bar fight between two strangers. We could have an assault that was motivated by someone's, religious background or sexual orientation or gender identity, or we can have an assault that's between two former intimate partners, but they're all going to be checked as the assault box. It's that victimization data, it's that next level. So yes, I do think that there's something that we can do in our statute that would perhaps enhance DCI's ability to collect data on bias motivated crimes so that we can have a more robust report, because it is very hard to develop policy and address issues when we're shooting in the dark and not really sure what we're looking at and what we're trying to get our arms around. And not all bias crimes are the same. I mean, what is the lay of the land in Wyoming? What do we really need to look at as far as how do we try to address it and how do we move forward? But so, I mean, to your point, yes, I do think I have seen Utah statute. I do like it. I went through that with Ms. King and I kind of delineated like, well, subsection B would be DCI, subsection C, and I don't have it in front of me, would be victim services. We could, collect that kind of data. And I believe there's a component about use of force with law enforcement. That was sort of another category. I don't know where that would, that'd probably be DCI's data, but also post, I mean, the ones who work with officers could be the repository of that. So I hope that sort of touched the surface on your question.
Yeah, quick follow-up on that. So the trying to find the point of entry, who's entering the data then, and it sounds like it probably ends up still being law enforcement at some level, but I'm curious, victim service advocates, I think you said all they could do is look at the report and whatever the police put in the report. But is that true, or do you feel like maybe victim service advocates may actually do they spend enough time with the victim to maybe gather something a little more, or are they truly constrained to what's in the report? And my point of that question is they may very well be one of our best options for reporting the data.
Ms. Chambers.
Madam Chair, Co-Chairman Olson. I was referring to my office with compensation data. And so we do just get the report, and it's usually compiled. So an advocate in the field or in the community would work with the victim to file a compensation claim. And worth noting is the fact that per our state statutes and per federal law, compensation requires a law enforcement report. And so a crime has to be reported to law enforcement, and we require not only the police report or a protection order, some other evidence of a crime in order to compensate a victim. And so my office only has that. You are absolutely correct. The advocates in the field would know, and they would have a better feel because they do spend that time with the victim. And so a separate conversation is this concept of non-reporting or having another point of entry for victims of a bias crime other than law enforcement. And I think that's very intriguing to me as someone who has run victim services for the past 10 years. I think that's, I think it would be much needed. I think there's a lot of individuals who would not report the crime for whatever reason. The model that we have in our state right now is actually not domestic violence, it's for sexual assault. And so we have a statute that allows my agency to pay for sexual assault examinations. And so that's for the purposes of not only evidence collection, but also to make sure the victim's health and safety, if they are the victim of a sexual assault. And that's one way that we can record data. Now it's de-identified, of course, because these are anonymous kits, but we would at least have numbers of how many kits are being done per year on these non-reported. We also, through legislation in 2019, took on the financial burden of all sexual assault kits. And so my division also would have all the data on the reported kits as well. And so that's something, so, that's one way. So the non-reported is a way to measure non-reported crime that I'm trying to figure out how to abstract, how to extrapolate that for this type of crime, because I know it's a question that has come up among the members as far as how do we serve these victims outside of a law enforcement mechanism.
Thank you, Ms. Chambers. Senator Cooper.
Thank you, Madam Chair, Ms. Chambers. I think maybe Co-Chair Olson touched on this pretty closely to what I was wanted to ask about, but on Ms. Creech's handout here, where it addresses 69102, that is a standalone law, if you will. What it's missing there is a reporting requirement. So would a few words of amendment to this 69102 statute take care of most of what we need? We already have reporting requirements by the DCI. So why can't we just ask for this data to be reported in the statute to the DCI, and then the DCI is already required to distribute that information. So the solution is really fairly simple. We're probably making it harder than it has to be. And then the second part of my question, ma'am, and it might be more for Judge Willing in the back room there, but is there anything now that prevents a judge or a prosecutor from asking for a stiffer sentence on an aggravated assault or something that's obviously fitting within this category? Thank you, ma'am.
Ms. Chambers.
Madam Chair, Senator Cooper, to your first part, that would be one solution. I mean, I would argue that we already have reporting requirements for all crime. And so I'm struggling with what more do we need to say? I think we have the statute already that says you have to report, data. It's that compelling it, or I mean, it's how do we compel performance? Real quick side note, I have spent 10 years going to not battle per se, but pushing back against national entities who will look at our statutes, again, in my realm, usually in victim statutes, and say, well, Wyoming doesn't have a law on this, or Wyoming doesn't have a law on that, or we have a failing grade on this because of X, Y, or Z. And I have to push back and say, well, you know what? We didn't have the most recently was we didn't have a statute to deal with our rape kit backlog. And so we had a failing grade. We didn't have a rape kit backlog. We still don't have a rape kit backlog, but we now have a statute that says if we were to ever have a rape kit backlog, it's addressed in statute. So I just want to say that sometimes when we get these national report cards, I just feel like, and I don't know, I went to law school in Wyoming. I've only really ever dealt in depth with Wyoming law. I don't know if we put our statutes in weird places or they're hard to find somehow, but I routinely run up against this, like, no, it's just over here. Like, did you look over here? And so I think this case, Senator Cooper's, we already have the statute that says you have to report the data. It's maybe getting creative on how we make sure that there's uniform compliance with that. And then you had a second part to your question, which may have absolutely flown out of my head.
Could, Ms. Chambers, it's, can the judges or prosecutors ask for a sentence enhancement or a further sentence for the same type of bias motivated crime?
Thank you, Madam Chair. Senator Cooper. I've never been a prosecutor, and you got one sitting right next to you, just, push Senator Kolb out of the way. She was vigorously nodding her head. And yes, I believe there's always mitigating and aggravating factors. And I believe Representative Oakley could speak more in depth about those, but there's always circumstances that come into any type of crime where you say this made it particularly more egregious, or, and those would be upon sentencing. Now, the difference between sentencing enhancements versus, a separate charged crime that has a certain penalty, I mean, these are different concepts, but sentencing enhancement would be different than just having a separate crime with a stiffer penalty, for example. I hope that answered that. But again, I would defer to prosecutors and judges.
All right, this will be the last question for Ms. Chambers as well. Representative Washut.
Thank you, Madam Chairman. Ms. Chambers, as I understand it, DCI in the state of Wyoming just recently finalized the transition to NIBRS, the National Incident-Based Reporting System. And in NIBRS, there's a data element for bias motivation. Is that the source of the 5 reported hate crimes in our data, or will we not see that for some period of time? When will we see the first, when will we see the first comprehensive NIBRS-based data for Wyoming?
Ms. Chambers.
Madam Chair, Representative Washut. I would have to consult with the CJIS Deputy Director about when our full compliance is anticipated. But again, there's always been federal hate crime legislation, and those data elements are in there, but the issue is who's checking the box. And so again, it's a multi-leveled approach. You have to, we probably need to make sure law enforcement understands. We have to have prosecutors understand. We have to have a more global understanding of what we're tracking, and then compelling that entry into NIBRS. But I believe, I thought we should soon have made the complete switch over. But again, I don't know how to address when I hear from the Deputy Director over Criminal Justice Information say we have law enforcement jurisdictions who don't want to enter data into NIBRS, and I don't know that we have a way to compel that. Other than we have a statute, but who's enforcing it, I guess. This happens a lot with the Crime Victims Bill of Rights. I've argued it's great we have a Crime Victims Bill of Rights. I would argue my division is in charge with enforcing it, but I don't know what I'm supposed to do if someone violates it. It doesn't have teeth.
We can make a felony. Just kidding.
You could address that, but that's your body's, role.
All right, thank you, Ms. Chambers.
Yes.
All right, with that, we're going to check the temperature in the room. I saw Representative Larson. I saw you. What is it? What is it? Let's take it down to 69. You're okay. All right. All right, 70. The age of our Supreme Court justices. All right, with that additional public comment, whoever would like to come forward, please introduce yourself to the committee And we will be cognizant for time. We are an hour over our scheduled agenda item, so I'd ask that you limit your comments to just maybe 3 to 5 minutes.
Certainly. Thank you, Chairwoman Nethercott and members of the committee. My name is Amber Pollock. I am a lifelong resident here in Casper, with the exception of a multi-year intermission that I took to complete my degrees at the University of Wyoming. I spend most of my time trying to contribute in a meaningful way to Wyoming's future, to do my part to make it one that is sustainable, resilient, prosperous, and vibrant. I'm a business owner, also currently serving on the Casper City Council. For the most part, I specifically focus on economic issues and our issues with youth retention. And I'm also a queer identifying Wyomingite. So I'm going to relay both some personal experiences and some broader perspectives that I've gained from my work over the years with Casper Pride, Engage, various economic development groups, and members of my community. And before I get into my prepared comments, I do want to just note a couple things that I've gleaned from the conversation thus far. I think the first one is perhaps the fact that we're having to spend so much time discussing whether we do or do not have this statute is an indicator in and of itself that it's unclear. And if it's unclear, it's not going to be effective. I think rather than get into, whose interpretation is correct, maybe we could look at what the impact is and whether or not that impact is actually delivering the result that we want, which would be, in my mind, the appropriate measure of justice for victims and victimized communities. And so I think the rest of my statements are going to be working under the assumption that we don't currently have that structure in place right now. I would also mention one more thing, 69102, a simple amendment to that, that would still leave out sexual orientation, gender identity, and a number of other of the groups that we have mentioned today. So I'm not so sure a simple amendment. I think that amendment would get quite a lot more complicated if we started to add those things in, but I do think it would be necessary. Wyoming is a state that is known to the world for one of the most high profile and impactful hate crimes in history. I have come to know this very well as a queer person who travels. It's very common for people to be surprised, shocked, in fact, that I live in Wyoming. Sometimes they don't even believe me. Because why would I live in a place that they identify so closely with Matthew Shepard's murder? They cannot believe that I would live here in a state that they perceive to be openly hostile to LGBTQ folks. This legacy is something that we like to try to ignore. We have worked hard to come up with alternative narratives to tell a story that absolves our state, our culture, and our people of any responsibility for the hate-motivated murder of Matthew Shepard. And when that doesn't work, instead, we say that it's time to move on because it was a long time ago. But the thing about moving on is that that requires some amount of reconciliation. You can't heal a wound if you don't clean it out first. Wyoming policymakers have not yet made a meaningful step towards reconciliation of this type. And in fact, many have historically resisted it vehemently each time it has come up. And the impact of this is that it continues to harm our citizens and our future. And at this point in time, it's been many, many years. I think it is bordering on irresponsible. I think it's irresponsible to our citizens who are living in one of only 3 states that has not yet seen fit to acknowledge in statute that hate crimes exist, that they threaten the life, liberty, and pursuit of happiness of some of our citizens, and that we ought to be taking steps to understand these crimes better, to punish them appropriately, and to track them so that we have accurate data to help in further decision-making. It's also irresponsible to our future, where this type of legislation is very clearly the baseline, the bare minimum that we should have on the books as an indicator that in fact we do want new folks here. We want people to bring their talents, their families, their business, and their dollars to Wyoming and contribute to our communities. I've been part of a group conducting focus groups of LGBTQ folks of all ages in my community for 2 years now. I would like to relay some of what I've learned through the process that has been enlightening, uplifting, and at times devastating. Universally, when asked what they love about living in Wyoming, most participants say that they say the same things that most non-LGBTQ folks would say when asked. They love the open spaces, outdoor opportunities, the people. When asked if they feel safe, many of them say they do, and they attribute that to the live and let live unspoken motto of Wyoming. But when you ask if they are comfortable out in the community with a partner, to try to date, to be open at work or with medical providers, the story changes. I have heard heartbreaking accounts of assault, harassment, defamation, and the like that make it clear when you start to dig deeper, there's a big asterisk in the LGBTQ community's definition of safety here. They feel safe as long as they can pass as a non-LGBTQ person in public or can avoid any situation where their identity might become known to someone who is unfamiliar to them. When asked directly, would you be comfortable holding your partner's hand or sitting close together in public? Nearly everyone said no. And some folks even laughed as if that was a preposterous idea. The fear in these cases was a fear of harassment and even more so a fear of violence. I wonder how many of you have had to think about that when going out to eat with your significant other. If you've had to be careful not to get too close or act like you like each other too much, in case there's someone watching who would wish to do you harm. You ought to see the looks that I get when I mention that our check will be together when we go out to eat. These situations are not purely anecdotal to me. I myself live with the same fears these folks expressed every day. Despite the fact that I am out and open, I still leave the state if I want some time where I can be free to dance with my spouse, to sit on the same side of the booth, or to go so far as to hold hands while walking down the street. And the weight of the asterisks on our safety wears us down because it is constant. It's the burden and the stress of always having to calculate how much of yourself you can be in a particular setting and what the stakes are if you were to miscalculate. Think about the impact of that on a person day in and day out over the course of a year and a lifetime. Passing this bias-motivated crime bill won't solve this problem, but it does help because it places some of the burden and impact of that bias where it rightly belongs, which is with the criminals perpetuating these crimes. And it gives the victims of these particular crimes a justice system that can more fully appreciate the unique impact of bias-motivated crimes and take that into account as a factor in the crime rather than be blind to it as our current statutes would have them be. This is a standard across the vast majority of the country that we have yet to meet. Our citizens deserve it and our state needs it if we are to make modern moves to live our values as the equality state and ensure that all who are here or who wish to come here and contribute to Wyoming's future are welcome. Thank you.
Thank you, Ms. Pollock. Questions for Ms. Pollock? Representative Yen.
I'm going to refer to you as counselor. Is that okay? Or councilperson?
Sure.
Councilperson Pollock?
Sure.
Okay, I enjoy the title. So Councilperson Pollock, do you think, so would you say that your testimony would generally have both positive economic and mental health aspects if we had an effective hate crime statute on the books?
Councilperson Pollock.
I think that would be one of the maybe unintended or intended, one of the side consequences of it. I think these things really do matter. Even just from a perspective standpoint, the impacts of this resonate beyond just the justice system. It gives a measure of comfort, of safety, of confidence in our state that I think we really need in order to make the type of moves that we need to make for our future.
Representative Provenza.
Thank you, Madam Chair. Thank you for being here and for serving your community. I'm wondering, as a member of council, if you have had conversations with your local municipality police department in terms of their reporting and how they're handling bias incidents here locally, and if it, you know, what has come from those conversations in terms of how we can move forward.
Thank you for that question. I have not yet. I just got on the docket to testify on this a few days ago, but it is on my list of things to do. I have discussed a few other issues related to the LGBTQ community with our police department, and so certainly have an open door for that conversation. Look forward to getting some more information from them about what we currently do and you know, how they feel about it.
All right. Thank you so much, Councilperson Pollock. We appreciate hearing from you. Further public comment? Yes, please come forward. And if you would introduce yourself to the committee with your name and who you're with.
My name is Jimmy Simmons. I have celebrated my 50th anniversary in being in Wyoming on the 10th of this month. I've served 16 and a half years as chairman of the NAACP, and I served 10 years as the first lieutenant of the Colorado, Montana, Wyoming State Conference of the NAACP. Today, I'm representing the Pikes Peak Southern Christian Leadership Conference as the vice chairman. I was recently appointed. We're trying to get civil rights organizations set up from, we only have one office west of the Mississippi, so we're going all the way to California, and I've been chosen as one of the ones to help get that accomplished. Racism is baked in the DNA of the United States government and the state government. Even as far back as candidate Abraham Lincoln was talking about the same subjects that we're talking about today. We're more interested in preserving the type of culture that we've created rather than the dignity of people. We here in Wyoming, we're more interested in preserving culture. And in doing so, I have to think about how Wyoming got its culture. When the government broke up the Ku Klux Klan, it broke up into 3 distinct organizations. I'm not going to call those organizations out because they exist in Wyoming. This culture was created through the act of hard work and passing miscegenation laws and hangings. Most of you don't know that Wyoming led the nation in hanging Black people between 1910 and 1920, which created a virtually all-white society. That's how you got to this point. Wyoming has handled hate crimes, and it appears we're at a point where you're validating racism and hate. I'm going to give you an instance that happened right here in Casper. 18 white men jumped on what we might call a mixed race individual with a white wife. It happened right over here in El Marcos Lane. An officer didn't intervene. He was there, but he did videotape the thing, and where he was able to identify 15 out of 18 of the perpetrators. The victim couldn't get this into court. He came to the NAACP, which I was president at that time. We don't have a hate crime law, but we do have a representative in Washington, D.C. at the Justice Department that told me, we know what Wyoming is doing. He used that term, spoke to me in a real firm voice. This is what you do. Do the investigation and send us the results of that investigation, and we'll take it from there. So that's how you're getting around not having a hate crime law. That's how you're doing it. So I did the investigation personally, sent the information to that individual. They pulled this guy in, they pulled one person out of 15 identified in and took him to court. The court fined him $400 and let him go. The victim, in a 24-hour period, the medical bill for the victim was over $35,000. That's how Wyoming handles hate crime when you take it to the court. You're soft on it, real soft. I testified last November in front of the U.S. Civil Rights Division. And I hear a lot about reporting here. And I'm going to tell you what we found out here about reporting. The information is being reported, but you have to know where they're reporting it at. We found out, and I had a face-to-face conversation with a former police chief here. He told me that there's no such thing as a hate crime, and how they're defining it is a, let me get it right here. It is suspicious activity in regards to bias. It's painted a different color and put in a different file. That's why it always appears that we're underreporting hate crimes here. There were 5 incidents in Campbell County where mixed race couples were attacked. Those were hate crimes. And I see the police department finally in Campbell County, their hate crime reports at that particular time equal the same hate crime reports that we had for that county. But it's violence involved in these hate crimes. You know, a black woman, a black man with a white woman. And I met with a Klansman. We called him on the carpet because after you have these hate crime incidents, Klan information was being circulated in that area. So I got with my board and told him that I was going to call this guy to the table. And I did. And I said, well, what do you consider these? He said, those are hate crimes. And I said, why? I said, what is the Klan most afraid of? We're afraid of a black man being with a white woman. He is considered a race destroyer. And this is why we're having those attacks like that, in my particular case, in this state. I was involved with writing a statement for tourism one time, and that was one of the things that came up. We're a state, and something that I've never heard talked about today. You cannot discount a police chief as not being a racist. You can't discount the judge as not being a racist. You cannot discount the legislators. There's been a legislator been reported as being a racist to us before. I'm not going to call his name because he's not in office now. But we assume that these people are going to be all right in dealing with race issues. Cyrus Western needs a psychiatric evaluation now. I know he has further political aspirations, but I feel that he is not, I wouldn't want this guy to represent me.
Mr. Simmons, thank you for your comments. I know I do have to get you focused back on the agenda at hand.
Okay.
Do you have comments regarding bias or hate crime reporting, which is our topic for the agenda?
Like I said earlier, I think your hate crime reporting it's been painted a different color and it's been put in a different file. And this is why we're being underreported. Thank you, Madam Chairman.
Thank you, Mr. Simmons. Appreciate you being here. Any questions for Mr. Simmons? Seeing none, thank you for being here, Mr. Simmons. Further public comment? Welcome. Again, we are very short for time. The committee members do have to drive home tonight.
And I will be very short.
Thank you. Introduce yourself to the committee with your name and who you're with.
I'm Rob Johnston. I'm president of the local Casper PFLAG chapter. And I'm the parent of a transgender daughter.
Wonderful.
So good afternoon, co-chairs and committee members. It is my pleasure to join all of you today speaking in support of the legislation that is before you for your consideration. I want to speak with you today from 2 perspectives. First, as president of the Casper PFLAG chapter, and secondly, as a gay man. In my role as PFLAG president, I often get questions or calls from parents and from young people just wanting somebody to talk to, somebody who can provide support and sometimes offer support to their parents. Parents often need to hear that what they need to do is love their children no matter what. PFLAG is the first and largest organization of gay, lesbian, bisexual, transgender, and queer people, their parents and family and allies with over 400 chapters in the United States. In Wyoming, we have PFLAG chapters in Casper, Laramie, Gillette, and Cody. Our goal as chapters is threefold: advocacy, education, and support. On October 28th, 2009, the Matthew Shepard and James Byrd Hate Crimes Prevention Act was signed into law by President Obama. Even with the introduction of this new law, the threat of hate-based crimes against lesbian, gay, bisexual, and transgender loved ones is at a critical level. Visibility for LGBT communities and their allies is at an all-time high, with a special focus on family acceptance, building safer schools, relationship recognition, and workplace fairness. Rarely do we find a person who does not have an opinion on these issues. Now more than ever, we must be able to build strong relationships with local police forces to help them better respond to and report these crimes of hate against our LGBT family and friends. When Matthew Shepard was murdered, I was living in Las Vegas at the time with my partner, who had grown up in Wyoming, first in Riverton and then as a faculty member at the University of Wyoming. He had hate messages painted on his office door at the university, and when he worked for the Riverton Ranger newspaper, his sexual orientation was often an issue with other staff. I met Carl when we were both living in Las Vegas in the mid-90s. He swore that he would never return to Wyoming. However, his dad decided to marry for the second time, and we traveled here to attend the wedding at the Tumbleweed Inn in Powder River, Wyoming. If you've been there, you know it's not much anymore. In 2002, Carl's dad suffered a heart attack and stroke. We came up here to see him and decided immediately that we needed to live here to make sure that he was going to be okay and take care of him as needed. Within 3 days, Carl found a job working at the Home Depot, and we bought a home in the Tree section of Casper near downtown. I moved up here several months later after selling the house in Las Vegas and was lucky enough to find a job as a contract employee with the Wyoming Department of Health, where I worked for 10 years. Everybody we knew in Vegas and my family back east had all said, "How could you move to the state where Matthew Shepard was murdered?" Even years later, friends of ours who would be coming to Wyoming on vacation were concerned for their own safety and well-being. We usually told them, "Don't be flamboyant, keep to yourselves, and try not to bring attention to yourself." Our experience was that they might be safe. After moving here, we walked downtown to have dinner one night and to see a movie. As we were coming home, a truckload of kids drove by and called us, if you'll pardon the expression, effing faggots. We weren't holding hands and we were wondering how they knew we were gay. But it must just be that it was to get those white middle-aged men walking together down the street in Casper. My fear that evening was overwhelming. I was afraid that they might turn around and harm us. Fortunately, we got home safely. But now I have not realized this until I was just putting this together today. We very seldom walk downtown now, especially at night if we want to go out to dinner or a movie. We drive. We park close to where we want to go and we try not to draw attention to ourselves. That is not living life to its fullest. A basic level of fear is always present. Is there going to be the time where someone bashes my car because I have a pride sticker on it? Is someone going to trash my house because I have a love everybody banner hanging by the door? Am I going to be confronted at Walmart based on a t-shirt that I'm wearing? I have a daughter who is transgender. She dropped out of high school here in Casper because many of the faculty and staff would not call her by her chosen name. I don't want her to be a statistic. Passage of this bill gives us protection and sends the message that no matter what, we are the equality state and we take care of each other. Thank you for your consideration.
All right, thank you. Any questions? Seeing none, raise your hand if you are going to provide public comment. Raise it now. If you don't raise your hand now, you will not be allowed to provide public comment. Are you thinking about it? All right, 1, 2, 3, 4, 5, 6. All right. Is there anyone online that's intending to provide public comment? If you're online and intending, do we have anyone in the waiting room? There's one. Oh, he's not providing public comment on this. Okay. So because there's 5 more and because My request for 3 to 5 minutes was not honored, and that took 30 minutes to hear from 2 people. Our time is very limited. We care deeply about this topic. We made it a priority for the interim, but we do have to drive home when, as we know, sunset is hitting and the game are out. And so I want to be very, very mindful of my committee members' time and their safety as they drive home and allow us to do good work. So your time will now be limited to 3 minutes, and there'll be a stopwatch. When you hear the sound, you will stop talking. All right, so the next person to provide public comment, please come forward. I need a stopwatch. Please introduce yourself to the committee with your name and who you're with.
Good afternoon, committee. I'm Debbie Herron with Walmart Stores. I am the Director of Public Affairs and Government Relations, and here on behalf of our company and the 4,500 associates that work in Wyoming. I will be very brief and try to hit your 3-minute marker. Really, we just wanted to say that we are in support of bias-motivated crime legislation as articulated by several of the presenters you've already heard from, Representative Sweeney, excuse me, and Jeremy Shaver. I think both articulated some of the tenets that need to be in this kind of legislation so that it is effective for those individuals who find themselves in a circumstance of being victimized. The reason that we support this legislation is because respect for the individual is a key tenet of Walmart's culture. When you come to work for the company, you learn about our 4 basic beliefs, and they are respect for the individual, service to the customer, striving for excellence, and acting with integrity. It is that respect for the individual that anyone is welcome to be a customer, to be an associate, and to be affiliated with the company that we want to support bias-motivated crime legislation here on behalf of our associates and for our customers. We look forward to proactively engaging with you over the interim. We're pleased that the committee took this on to consider such a serious measure over the next few months, and happy to stand for any questions. Thank you.
Thank you so much. Go ahead and proceed. I see the UPS.
Yeah, hi. My name's Sarah Sprung. I work for UPS. I live in Cody, Wyoming. I have the top northwest corner of the state from Sheridan, Riverton, Thermopolis. The whole area is my operation. So Chair Nethercott, Chair Olson, and committee members, I want to let you know I've been with the company for 19 years, serving in numerous capacities. I want to thank you for your time today to hear why bias-motivated crimes legislation is important to UPS. UPS has over 750 employees in Wyoming at more than 14 different facilities, serving every community in Wyoming's 23 counties, all across the state. Each day, UPS travels throughout the roadways of Wyoming, providing transportation and logistics service to thousands of Wyoming residents and businesses. We are all integrated into the communities of Wyoming, no matter how rural or remote they may be. As a company, we are committed to and driven by values of integrity, safety, and sustainability. These core beliefs guide us not only in our work, but in how we live our everyday lives, with the understanding all individuals deserve to be treated with fairness and dignity. Our people are UPS's most valuable asset, and we have all come to realize how essential they truly are. And at UPS, we believe the greatest strength of our people is the diversity amongst them and the unique qualities that each one of them brings to work every day and to those they serve. We steadfastly believe in our duty to ensure UPSers and individuals in Wyoming and throughout the nation are able to experience these values in their workplaces as well as their communities. Guided by those values, we believe now is time to consider supporting the passage of bias-motivated crimes legislation. Through the federal level legislation exists, we believe every state should definitively affirm that crimes committed as acts of bias and prejudice have no place in any community or state in our nation. Nicknamed the Equality State, Wyoming has a long history of being a pioneer when it comes to equal rights, and now Wyoming has another opportunity to discuss and advance meaningful policies to support the positive change and social impact communities need in order to build a more just and inclusive state and nation. Our communities need strong solutions and specific actions in order to eradicate racial injustice and inequality. We stand united across the entire U.S. against violence and hatred. We understand that these discussions are difficult and solutions are not simple to find, but a bias-motivated crimes law is an important step to build a more inclusive Wyoming and world. We, along with others here today, are committed to working with all stakeholders to create a safer and equitable environment one in which everyone's voice can be heard and protected. For us, the passage of bias-motivated crimes legislation ensures that Wyoming prosecutors and courts can provide justice for any Wyomingite that has suffered from a bias-motivated crime, and that there will be consequences in place to deter people from committing crimes towards others simply because of the unique qualities someone may possess. Supporting the passage of this legislation in Wyoming and other states shows that as UPSers, we are truly living the values of our organization, not just talking the talk, but walking the walk. Once again, I and all of UPSers, thank you for your consideration and time today. Try to go fast.
Great job. I hope, any questions? So I do think it's important. So Walmart and UPS are both here recognizing that that's important for your corporate positions to be in support of this. Okay.
Yes, Chair Nethercutt, it is our corporate position to be in support and representative of all of our associates here in Wyoming.
All right. Representative Zwanitzer.
Thanks, Madam Chairman. And those of you who don't know, especially Deb is like the Walmart person for 5 or 6 states. So it's not every day she comes to Wyoming. I guess maybe you come here more often than I realize, but I think it's been a while. And it's not a revenue issue on my committee, which is, we got her once in a while for revenue when we're in a tax. But I guess my question is why overall, right? I mean, I understand it's part of your corporate mission statement, but that necessitates, I think you live in Portland. I mean, flying all the way here to testify before us. What is it, is your organization internally, are there issues in Wyoming you've heard from your stores, from your people? Are you looking at expanding here? And because we don't have these type of laws, we're holding you back? I guess any more on your corporate mission and how Wyoming fits into that based on this? We don't get you here often, and it must be a big deal to testify for 5 minutes on a Tuesday in Casper. So I wanted to give you any more allowability.
Why are you here in Wyoming?
Well, Senator Nethercutt and Representative Zwanitzer and all the members of the committee, it's been a while since I've seen you in person. So it was, a great opportunity to do that. Plus I like traveling. And I think my 13-year-old is happy to have me out of the house for the day so that she can get away with the things that her dad doesn't notice. And if she's watching me on TV, she should be doing her homework. In all trueness though, great question. And the reason that this is important is because our stores and our company are made up of the fabric of the communities where we are. Most of our associates live within 2 miles of a store that they work at. In Wyoming, that's probably a little bit further because there are communities that are naturally more distant than other places. But we are also representative of all of those individuals, their beliefs, their perspectives, their lifestyles, their identities from the time they walk in the building. And it is important to us that associates and customers feel safe. We have, over the last 15 months, been dealt with a number of circumstances where strangers are having conversations because of other types of state regulation that was in place for periods of time. And so having bias motivated crime legislation or statute on the books means that for the individuals that want to move to Wyoming for a job opportunity, for a promotion, for a career advancement, or maybe they've been with the company for 30 years and they've never lived in Wyoming and a job comes up and they want to try that. For them to be able to come to work and feel the same safety or to feel safe is a really important thing for us. And that is why we're here. Thank you for the extra question.
All right. Thank you both for being here. We appreciate your testimony. Thanks for making the time.
Thank you.
Further public comment? All right.
I'll try and speak as fast. My name is Tyler Sesser. I am representing both the Engage Council, so I'll speak on their behalf first. And thinking about how every summit that we go to and every survey that we put out, we have over 300 people that come to the summit, and a vast majority of them describe the experience of discrimination or the lack of protections against discrimination as one of the reasons for leaving the state. So we talk about often, right, the flight of youth from this state, and that is one that we routinely see come up regularly. We will be holding another summit on October 1st and 2nd. I would hope to see some of you folks there. We'll be liaising as we can throughout the year. Secondly, I've also worked with the Wyoming Independent Citizen Coalition. We've addressed things at school district level, like representation in from South Cheyenne. The amount of burden that is on non-dominant communities to report those crimes or report discrimination is overwhelming. We went through a whole year of attending school board meetings saying that South Cheyenne feels it's underrepresented. South Cheyenne feels underrepresented. Hispanic leaders, Black leaders went before the school board and said, we are not represented by this school district. We had to use many different tactics to find ways to get that and make motion to ensure that there was representation. And after over a year of work, the community finally got it so that there was a dedicated seat for South Cheyenne on the school board. And that was painful. It took energy, it took emotion, it took reliving trauma. I think right now, in my final seconds here, what I want to acknowledge, and I don't miss the irony in the fact that we just had two queer folk, one Black person come up here and relive their trauma, stay perfectly within a reasonable amount of time, within 5 minutes. And directly after that is when we were admonished for going over public comment. But yet the people that were presented before were given endless amounts of time with no warning. So I think it's interesting that when we think about the concept of reporting, what would that look like in that victim room? What would that look like when you're trying to go report discrimination, when yet in this room, we didn't give the time to two queer folk and one Black person to give their full account of their experience. And then that feeling like after you leave going, oh shit, I took too much time. So with that, I will stand for any questions. And I do really appreciate you considering this whole conversation.
You have 40 more seconds left, Mr. Sessler.
Oh, I do?
I encourage you to take it.
Yeah, I just think that when I think about in my other job, think about the role of creative expression. It was a massive pushback on just having the art of pride. We faced a pretty big pushback from the community and folks leaving, yelling slurs, coming in, taking work while I had a queer. We had one of our guests. She's been coming for weeks, and actually they have been coming for weeks since January, and finally felt that they could express themselves in the one group that we have that's LGBTQ focused. And as they were leaving one day, a member came in and yelled at me for pushing my queer agenda on folks. And that young person who felt safe had to witness that. So I don't think that in particular is a crime, but it is unfortunate. But there are far worse crimes that happen that I hope that we can have a meaningful punishment for it, because that's what deters people and keeps those numbers low.
Thank you, Mr. Sessler. Questions for Mr. Sessler? Senator French.
Just a comment, sir. I resent you implying that our good chair is somehow biased against the Black person and the two that identified that your words that were queer, that we're cutting them off in time, and that we're giving the others ample time. She has said over and over and over and over that we're running late. And I have 4.5 hours to drive when this is over. So I resent your comment. You're out of line.
Thank you, Senator French. Mr. Sessler, no need to respond.
May I respond?
No. Thank you. It's not an engagement, so it's not a question. Thank you, Mr. Sessler. We appreciate your testimony. Appreciate you being here. Members of the public, I know this is a tough subject. Trying to be mindful of everyone's time and be respectful. Representative former Representative Burlingame. Raising her hand.
Thank you, Madam Chairwoman, Mr. Co-Chairman, and members of the committee. I'm grateful for the opportunity to briefly address you today. And I'll be brief. As I drove up yesterday from Cheyenne, I was thinking about if I would testify today and what my remarks would be. And I saw that the Platte River was high and the plains were real green. And I was thinking about how gorgeous our state is and how it shouldn't be any problem at all to attract businesses to the state of Wyoming. Who wouldn't want to move here? I just got back from the Central Valley in California, and I thought, how do they get people to live here? But one of the things that Wyoming Equality does that is not on any of our mission statements or visions is we pinch hit for companies who have done national and sometimes international searches to find the very best person to come to our state. And if that person happens to be a member of the LGBTQ community, they want to know, will I be safe there? Because all I know about Wyoming are a couple of films, pretty famous hate crime, and maybe if we're lucky, the rodeo. And more often than not, that person has been brought into Wyoming for an in-person interview. And if they come here, they fall in love with us and they see we're real friendly and that we're warm and we're welcoming. And sometimes it's their spouse that I'm called in to speak to. I don't know what that says about their marriage, right? That like, maybe trust your spouse, that they said, it looks real nice. Honey, I think we can move here. But it's my job to say, hey, what are your fears about moving to Wyoming? Because I don't think that we're uniquely bad. I actually think we're uniquely good. And I don't think that there's a better place on earth to live. I'm a member of the LGBTQ community. I make my home here because I love it here, as do all the LGBTQ people who choose to make their home here. But the chasm that they see is between what our laws say we are, what protections and what values we reinforce in our statute, and what I hope they feel to be true. And the truth is, I think we are warm and we are welcoming, but we don't always live up to that value. And I see this statute, I see this bill as one way of doing our job. And when I say, to these folks, please come make your home here, I think you'll really like it. And they ask, why haven't you passed a hate crimes bill? Why isn't there non-discrimination in Wyoming? If you're the equality state, if it's these things that you say it is, my best, most generous answer is that the legislature in the state of Wyoming does what it does best, which is move slow. We aren't capricious. And we move slow because we try to be thoughtful. So I hope that the process that you're involved in today is the right process. It's a thoughtful one, and it takes into account enhanced sentencing. It takes into account all the factors that you've heard today. I think that's the right process. And I'm just going to ask you to move this process forward. I hope that there will be a bill, and it's a bill that we can all take a good whack at and do the thing that y'all knock doors on to say that you do. See how we can best serve the people of Wyoming. I'd stand for any questions.
Thank you. Any questions for former Representative Burlingame? Right. Appreciate hearing from you. Deacon Lehman.
Thank you, Madam Chairman, members of the committee. I'm Mike Lehman, representing the Catholic Diocese of Cheyenne, and just taking it a step out. One of the reasons the diocese continues to advocate on another issue, the abolition of the death penalty, which I know is a unifying issue for this committee, but is because we believe that government must be limited. While government is necessary, while government is, dare I say it, good in many cases, its power must be held in check. And then to turn right around and say it's the act of pulling a trigger on another human being, another life, we completely trust the government to do that, seems to undercut all the efforts we make towards religious freedom and freedom of speech. And so that's one of the reasons we do that. Likewise, in my opinion, there are some similarities in looking at this. Naturally, there needs to be an effort to look at motive, to look at intention behind crimes, but to sort of grant the government the ability, and we trust them to look into the hearts of human beings and exactly what's driving these actions is a little bit a reason to be concerned. We've been told that tracking hate crime penalty enhancements or laws will not impact free speech. I'm not completely convinced of that. Whenever we see a high profile crime happen around the country, what happens is the media begins immediately scouring social media posts, these sorts of things to determine motive, what was driving it. To think that our young people won't grow up in this environment and recognize that things, the ignorant things, the uninformed things that they say might not potentially be held against them sometime down the road, I think is a little naive. Growing up in Wyoming just a few decades ago, free speech was palpable. You could feel it. Why do I know that? Because we kids said a lot of dumb stuff. We did. And the thing is We lived to tell about it. Nobody canceled us. It was a wonderful learning environment because when you had a bad idea and it came to the surface, our parents, our aunts, our uncles, our teachers, our pastors were free to come in and help us think just a little more deeply about those naive, ignorant things that we were saying. And they were free to do that without themselves being canceled. In fact, that's what we want. We want an environment where young people feel free to let their imperfect, uneducated ideas come to the surface so that the more wise amongst the community can help them grow in their level of understanding. Anyone who doesn't see that the freedom of speech is under threat in our country has likely never said anything to challenge the direction of the culture. And so that's one of the considerations that I would throw out there. I know the cultural cancel or the cancel culture is different than the government threat to freedom of speech. But I think that's something that should be considered. And I thank you for your time and stand for any questions.
Thank you, Deacon. Appreciate the plug for the death penalty. Any questions for the Deacon? All right, none. Thank you for being here.
Just to clarify, that was a plug for the abolition of the death penalty.
Who's to say? All right, please come forward. I think come on. Welcome. As a quick reminder, please introduce yourself to the committee and share with us your thoughts.
Senators, representatives, thank you for this opportunity to speak in front of you today. My name is Elena Medford Johnson. I'm the proud parent of a 15-year-old daughter who found the courage this past week because of the Pride events to come out to me as a lesbian. I am here to represent myself, my daughter, and all of the LGBTQIA youth who have no protections against physical and mental harm. I'm a former middle school teacher and am currently in the process of creating an affordable and retainable self-defense program that will specifically cater to different targeted groups, some of which will be for the different groups within the LGBTQIA community. This past Thursday, during one of the Pride events at Art 321, my daughter and her friends wearing their Pride flags were surrounded and attacked by a group of high schoolers. They were calling them every homophobic name, and I will not repeat any of those. They were bawing at them and making crude gestures. My daughter had texted me while I was at Art 321, and I sprinted down there. And when I stepped in to stop this horrific mob, they started shoving me and chest bumping me. And one of the teenage girls slapped the phone out of my hand, causing it to tumble to the ground and crack the camera lens and leaving a red mark on my arm, like my hand and my wrist. One of the girls that was with my daughter's group called the police, and he informed us when he got there that there was nothing he could do about this mob, even though we were being threatened with bodily harm and death. And also I was physically assaulted by this young teenage girl. I did argue that I would like to press charges, and that was the only thing that I was able to do, is press charges just for me and the assault against me and the property damage on my cell phone. He would not offer any protection or safety, even any protections to escort us to safety either. The officer, as soon as he was finished with me, he went and spoke to the other girl, and then he left. As soon as he left without saying anything to us, excuse me. As we tried to leave, the mob of teenagers swarmed us again. This time they took our bags, they took my car keys, they took our water bottles, they were taking the kids' pride flags and taking video and pictures of us. And the comments and shoving us around. Sorry, I apologize. I called the police. Oh, I apologize. They essentially played monkey in the middle with us, and we could not leave. We were surrounded, about 20 teenagers in that mob to 7, 1 adult and 6 children. The police were called again, but this time I was told that they would not even send another officer to the scene, even though I had to explain that we were surrounded and that we could not leave because they had taken my car keys and they had created it so we could not leave the area.
You're running short on time.
Okay. Because of this, I asked.
Just wrap it up.
My daughter has been bullied by this, and on Sunday she tried to take her own life because there are no protections for these kids. They cannot protect themselves. She is in the hospital right now, and she doesn't know where to go or who to turn to because there are no laws that will protect these children. There are no laws that will protect this community. We need to do better. There needs to be laws that specifically cater to this. Thank you.
Ms. Johnson, thank you. Thank you for sharing your story. We're sorry to hear about your daughter. We wish the best for your family. Mr. Steenbergen.
Madam Chairman, committee, I would not dream going a second over for Chairman Nethercott. She used to be my chairman at the Greater Cheyenne Chamber of Commerce, and I don't want to feel her wrath. So sure you don't either. Thank you, everyone, for giving me the opportunity to speak to you today. You know, I've sat and watched this legislature for the last 3 or 4 years wring their hands and cry in their soup because we are in trouble as a state if we don't figure out some ways to improve the economy around here. Right. And so we give money away like a bunch of drunken sailors, millions of it, to these companies to try to do what we have for years to try to create an incentive. And what has happened? A big fat nothing. Still in trouble, right? So why are these companies going to Colorado? Why are they going to Nebraska? Why are they going to South Dakota and going right past the state of Wyoming? I would make the argument to you that there are many other things important to them. You have a letter there from part of our coalition. I think there are about 50 companies on that list, including organizations in this state, the Wyoming Business Alliance, the Wyoming Lodging and Restaurant Association. I know that Chris has also sent you a letter. Folks, this is important to business. This is an important issue. And we're sitting here talking about maybe we have one, maybe we don't. You know, it really doesn't matter whether we think we have one or not. What it really matters is the people who are making a judgment on us are convinced that we have addressed this issue. Right? How do we know that? We were at a chamber conference here about a month ago, and I asked the Wyoming Business Council, I said, hey, do you get asked this question? They said, we get asked this question all the time. Every company that looks at Wyoming of any size asks us if we have addressed this issue. Now, I won't try to tell you that, and they said it too, that there have been decisions not to come here simply because of this one issue. But I think what it does indicate to us is that we need to address some other things so that we can entice these companies to come here because it's important to them. Would also give you an example from the United States Air Force. Last fall, I was on a call, and I'm on a global strike civilian advisory group. And on the civilian advisory group, they were going around and telling what they needed from each state. You know what it was from us? You need to do something in your state to deal with our minorities, with our lesbian and gay soldiers. We need you to help us with that. So let's get this fixed, folks. You know, as we talk about this, there are only 3 states. Every business organization knows it. It's us, Arkansas, and South Carolina. There's 3 of us. Let's get it dealt with. And this is something we should have had dispensed with a long time ago. I appreciate your time, and thank you for listening, and thank you for taking this up. We'll look forward to you discussing it as we move forward. Thank you.
Thank you, Mr. Steenbergen. Questions for Mr. Steenbergen?
Yeah.
Chairman Olson.
Yeah, thank you, Madam Chairman. Dale, appreciate your very impassioned testimony, as I've been wringing my hands for 3 to 4 years and spending countless hours away from my family trying to make Wyoming a better place. I don't know what the legislature is going to do at the end of the day, but if this is apparently the golden egg that solves the economic problems of the state of Wyoming,
I'm gonna make sure we have an appropriation for a big old gold statue of you on the Capitol grounds, Dale.
You better use the golden egg for education. And certainly I'm not here trying to make the argument that this is the golden arrow. What I'm telling you is that companies are more socially aware than they ever have been, and that this is an issue for them. And if we want companies and we want employees, we're going to have to understand that. Now, we can choose not to have the companies and choose not to have the employees, and I guess you'll end up raising my taxes to cover that. Or we can embrace it, and not just this, but other things too. And over time, we can start chipping away at the rock.
Thanks, Madam Chair. Is it fair to say, in this case, many cases before, perception really is reality? And I think as former Representative Burlingame said it, when we have these companies, and I think we're all aware that maybe 5 companies we've attracted with more than 100 people to Wyoming in the past decade, or a certain segment that probably don't care about what we, an industry called diversity, equity, inclusion laws. But everywhere I go, I mean, both coasts, you say Wyoming, and there's 3 things come to mind, and it's Brokeback Mountain and Matthew Shepard, and why would anyone ever live there? Because it's just this perception of what it's like here that companies won't even come in. Have you experienced that personally with the Chamber of Commerce? I know the Business Council has made that. I've talked to them about it many times, and they've said, yeah, companies have a checklist, and no, they don't check box number 4 because we don't have a hate crimes law, and we're not even in consideration. But in your work as Chamber of Commerce, have you had businesses express thoughts on this or not come to Wyoming?
We have a lot of businesses that express concern over it. And I think what we see nationally, I just went off of the Association of Chamber of Commerce Exec Board, which is our national organization, right? And so we have all these companies that sponsor us, you know, companies like Microsoft that have data centers in Cheyenne, and certainly many other companies. But they all are working with us on diversity, equity, inclusion. How they said, look, if you want to solve workforce issues and you want to be able to get businesses to your communities, here's what you're going to have to start working toward. And they push it. They have pushed it with chambers since about 2014, 2015, especially, as they could see this tidal wave coming, a real fight for economy in states. And they're trying to help us. Here's how you get us. And so we are bringing that message back to you.
All right, thank you, Mr. Steenberg. And any further public comment?
I went 259, just for the record.
I know. All right, public comment is closed. Committee, back to you. Senator Cooper.
Thank you, Madam Chair. A little side note, to kind of add to what the gentleman just was talking about, companies not wanting to move here. Actually, there is a company moving here from Southern California as we speak. And the reason they're moving here is because of the religious persecution they had in Southern California. They came to Wyoming. I mean, the laws in California are in place. It's still happening. They're coming to Wyoming as we speak. They're moving their whole company here because it's safe. They can practice their religion. They can run their business in the style that they feel is necessary in a safe, positive environment. So for everyone that you see, think about that. There's people out there that are coming here just because it is safe here. So I'm not sure all these arguments are 100% valid. Thank you.
Looking for action items from the committee. Committee, we started off the conversation and the topic is reporting requirements. And I think that that's an important place to go back to, is understanding some of those reporting requirements, and to Senator Cooper's point, which is whether or not the stories are accurate or not. And so certainly there's always challenges with any kind of reporting and data for crime, but no data certainly is not helpful. And so do we want to take action similar to enhance what we currently have in our statute, or to do something similar to Florida or Utah, which I think is easily accomplished? That's really a question for the committee to consider for an action item from this. Representative Washit.
Thank you, Madam Chair. I just want to emphasize that the switch over from the old uniform crime reporting data system that Wyoming law enforcement agencies have participated in voluntarily for many, many years since the 1930s to the new NIBR system, the National Incident-Based Reporting System, is night and day different. The detail that we're going to get about victims and offenders, their relationships, the demographics will be much, much more enhanced under the NIBR system. So I'm thinking maybe we're a little premature if we try to move forward with something right now. I think we can get another report at our next meeting from DCI with the details about this NIBR's transition and when we're going to see that details. And then we can make a better judgment about enhancing reporting requirements. Just my comment.
So sensing that, I think Representative Washington has a good point that it might be valuable to bring to the meeting rather than invite DCI and have an understanding of that NIBOR system. And then also what type of teeth we can put into the law requiring local law enforcement agencies to more accurately report data, all of the information that we need to really fill in those gaps. And so we can continue this conversation into the next meeting based on the need to hear from those stakeholders. Representative Yin.
Thank you, Madam Chair. So what I would say is that when we heard from Ms. Chambers was that one, we don't have teeth, but also two, a whole district is not interested in reporting into NIVARs. So I think we need to get these people to the table. And if we just say, please come to our meeting, that may not do it. And I don't want to keep having meetings where they don't.
We can subpoena them.
Show up. But I think one thing before we get to the point of a subpoena, Madam Chair, would be have a bill draft to have a reporting requirement on those prosecutors so they know that if they don't show up, then we just assume that they're okay with it. So I think a bill draft creating a reporting requirement would be useful to get the prosecutor's voice to the table because they're sorely lacking here. And I'm not sure why when they were willing to participate in our meeting yesterday.
I think to respond to that, I think the NIBR system is inputted by law enforcement, not the county attorneys. So they receive that data, but don't necessarily input it. They do input some data, but they're not the primary source of the information for that piece. So clearly, I do think that there's additional information for the committee. I don't think that there's any harm in doing a bill draft. So Representative Yin, was that a motion for a bill draft?
Madam Chair, so moved to put a reporting requirement in our current statute with Senator Cooper's recommendation that we just inserted in our current statute where we have that non-discrimination portion and use that as a starting point.
Do you like going back to Ms. King's handout, which provided pretty helpful information from other states? Did you like Utah? Did you like Florida?
Madam
Maybe to
Chair.
provide some more specificity for LSO and doing that bill draft.
Thank you, Madam Chair, for that opportunity. I think using Utah's statute as a starting point would be good. So I would make that motion, Madam Chair.
Is there a second?
Second.
Okay, moved by Representative Yen, seconded by Representative Monitor. Does everyone understand the motion?
Madam Chair, I would add a reporting requirement for bias motivated crimes with the basis of using Utah's law as the model.
Discussion? Representative Craigo?
Thank you, Madam Chair. Just a question for Representative Yin is, are we amending or adding the reporting requirement to 69102, or are we just adding it to 71102? Okay.
Further discussion?
Just a request that we keep it, I guess, broad in the bill draft and we can always narrow it. I'm not exactly sure when I say reporting requirements, if we're covering everything that was mentioned today from Ms. King or from ADL,
I think we're taking it from Utah.
or just take Utah's and start that? Okay, as a basis point. Thanks, Madam Chair.
I would say to that point, my observation of Utah's statute, that it's actually less superior than others when it comes to hate crime particular issues. It's really good on use of force. But I don't think that's the issue in front of us now. So interesting piece there. I think Florida has a good piece, but that's the motion and we can certainly tweak it at the next meeting. Senator Cost?
Thank you, Madam Chair. I don't know when the new reporting is going to start coming out, but the 2019 DCI shows 5 people as far as guilty people, and the hate crimes and all were very limited as far as what's there. So if it's already started, I'm a little concerned there's not much there. So hopefully the new is starting now and not in 2019, which is the most current that we have DCI.
Further discussion? All right, seeing none, all of those in favor of Representative Yen's motion, please say aye.
Aye.
Those opposed, say no.
No.
All those in favor, please, the chair is in doubt. All those in favor, please raise your hand. All those opposed, please raise your hands. 10-5, that motion passes. All right, further discussion on the bill or on the topic? Representative Zwanitzer?
Thanks, Madam Chairman. I'd make a motion to draft a, I guess I would call it a basic bias motivated crime bill that would be kind of comprehensive on the things listed from ADL's chart with a, what's the minimum for a felony? 1 year for
It's just called the felony.
just called a felony with, okay.
Okay.
With a 1 year provision, whatever the minimum felony is at a starting place that we could at least have a bill draft to discuss for our next meeting.
So Representative Zwanitzer, this would be potentially taking our current statute, the 6-1, and you would like to also have a provision for that to be a felony because it's currently a misdemeanor.
Yeah.
And then you want to add in these particular, what additional classes would you like to add into those already listed in our current statute?
I guess, Madam Chairman, my motion would be maybe nothing more than the current statute, but up to a felony provision. I'm at the point where perception is reality, and I don't know if everybody else travels out of the state very often. But we have a pretty bad rap out there, and we're not getting businesses no matter how low our taxes are until we get some stuff on DE&I, the new trendy, woke, diversity, equity, and inclusion language. We need to have something so I would up it to a misdemeanor to a felony so we can have something on our books and go from there for discussion our next meeting.
Is there a second?
I'll second, Madam Chair.
Seconded by Representative Yen. Discussion?
Yeah, Madam Chairman, I could always do this later when there's a bill draft, but I would have a friendly, hopefully it's friendly, amendment to the motion. Looking at the categories, I would include religion.
It is missing.
It's missing from our current statute.
Although Co-Chairman, it does say creed.
Yeah.
And I do think that's an interesting history that I would ask LSO for our next meeting to, without spending too much time, is maybe understand that history for why religion is not listed, but creed certainly is. And those certainly could be similarly interpreted, but I do think that's an interesting piece for that Wyoming chose to use the word creed instead of religion. We could get some maybe background history on that.
Madam Chair,
Yeah.
and now that I look at it, it doesn't have disability either. So I guess I would ask for it to be expanded to disability, religion, gender, anything else under the 1964 Civil Rights Act, what's considered basic language as part of the bill draft.
Anyone want to add any more? Senator Cooper?
I'm a little not clear on what it is we're trying to do here. Are we amending 69102
Correct.
to
Have a felony
include the proper
provision.
language and a felony?
Representative Wanetter's first motion was just to make that a felony. And then Co-Chairman Olson recognized the absence of the term religion, at which point I acknowledged the term creed. Then Representative Swanitzer recognized the absence of disability and wanted to add that in. So right now, the motion, which I assume is friendly by Representative Yin, who seconded, is that to do a bill draft amending Title VI to have a felony provision, also adding in the provisions for religion and disability. That's the motion, seconded by Representative Yin. Just say yes or no.
Madam Chair, yes, it is friendly. I do want to point out that if that I don't want us to get all hung up on the list, right? It's a bill draft and we will have an opportunity to work a bill draft.
Further discussion? I think one piece that is missing here for LSO in understanding how to make it a felony is probably, and looking to my county attorneys and the attorneys on the committee, that and this is what makes the law somewhat unworkable and likely why there's no prosecutors who are using the statute currently, is because you either have a misdemeanor simple assault or an aggravated assault, which is a felony. And the motive as to why is irrelevant as to either crime. And so the underlying crime still needs to, what is the distinction in this case, Representative Swanitzer, between a misdemeanor and a felony crime? What is the conduct that is different, that automatically triggers it from a misdemeanor level offense to a felony level offense? For a typical assault, it's the level of injury involved. Correct, prosecutors? Representative Oakley?
Thank you, Madam Chair. So I guess what I'd say is if we're taking 69102 as it stands, let's say, or again, we might discuss that and just change it to a felony. We don't need to have something that is an additional act. We're saying this conduct is a felony. What you're talking about, if you have like a battery and then aggravated assault and battery, there's higher elements. So if we wanted to keep 69102 as a misdemeanor, let's say, if we wanted a felony charge in addition, like two separate, then we would have to distinguish and have a higher conduct. We don't have to have that. And we could just say we're make 69102 as felony.
All right, that's the motion. Any further discussion, or we can amend it at the next meeting too? All right, all those in favor, please say aye.
Aye.
All those opposed, no?
No.
Or some emphasis in the no votes, and they made it unclear to me. All those in favor, please raise your hand. All those opposed, please raise your hand. Okay, that motion has failed. I think with 5 to 8 or something, okay? All right, further discussion, Representative Yen?
Madam Chair, I have a question, maybe if anyone on Judiciary knows or if LSO knows. Do we have any crimes against intimidation or threat of violence?
Representative Yen, that can be considered an assault. A battery is when you touch them. Battery means bruise. Law school exam. Further discussion? Representative Swanitzer?
Thanks, Matt. I guess I've been in the legislature too long. Two of the largest corporations in our state and the Chamber of Commerce have come to us saying, do something. I'm not sure what the something is, but I just can't believe we're not going to have something that we're going to ask to be drafted to continue to look at. I mean, I guess we didn't do that for juvenile justice. We didn't do that. I'm struggling here on our purpose of this committee, even for reporting requirements. I guess we have something moving forward, but if anybody has any suggestions that they think would be workable and agreeable to the majority of us to have a discussion on the issue, I would second it. I'm just not sure exactly to people who are
Well, Representative Swanser, I mean, I have always on the topic said that I would consider supporting a sentencing enhancement. So if someone would like to bring a motion, I know that wasn't very popular. The ACLU has maintained a consistent position that they don't believe sentencing enhancements create any kind of deterrence to crime. I don't necessarily dispute that fact. And so those are important considerations for all the stakeholders to consider. I also don't know, I think it's true, back to Senator Cooper's point, that Wyoming judges and prosecutors certainly, if the facts present themselves as indicating that bias was a motivating factor in a crime, that is certainly argued at sentencing and a court takes that into consideration. Our sentencing statutes are structured in a way that it's like 0 to 20. And so there's a lot of discretion given to our district court judges to make appropriate sentencing decisions. And they weigh a lot of considerations into that. If we want to statutorily tell them, legislatively tell the courts that they should certainly make, if there's evidence of a bias motivated crime, that there should be some type of discretionary enhancement associated with that, then that's something for this committee to consider, if you'd like. Representative Crago would like to make a comment.
I was just nodding in agreement, Madam Chairman.
I just wanted that on the record. Senator Cooper.
Thank you, Madam Chair. Voting no on the last motion. My problem with it is primarily the fact that it made everything in that category a felony. Some of the things that are going to happen definitely need to be addressed: harassment, stalking, whatever it may be, but they may not be felonies. They may not reach that. So without the word felony in there, I do believe that 69102 needs to be amended to include the language necessary to include the sexual you know what I'm trying to say. It needs to have all the right language in it, but it.
Senator Cooper, are you making a motion to amend the current statute in Title
No,
VI?
I'm not yet. I
Okay.
just out there for discussion. Thank you.
Representative Yen, I'm gonna pound my gavel.
Madam Chair, if I may, I will make a motion just to have us have a vehicle to have a discussion, because I think that is extremely necessary. And if the vehicle right now is just add religion to our 69102, I'm willing to motion to have a bill draft to have that, to have both religion and disability on that list. And then we can have a discussion if that is the right approach going forward at our next meeting, just so we have a vehicle going forward, Madam Chair.
There's
So
a
I make that
motion by Representative Yen. Is there a second? Seconded by Senator Cost. Discussion.
Yeah,
Co-Chairman Olson.
a couple of points. Yeah, number one, I think this is we can work the end goal through that legislation in terms of the penalty. Obviously, I'm not for creating new felonies, so that made me a little uneasy. I also know the history of the House of Representatives when it comes to enhancements and felonies, so I already know how that's going to end up. But so I think this is that's a good approach. I also do want to say this. I don't know what the master list is out there in the universe that the corporations look at for statutes and they say, aha, yes, oh, no, Wyoming. But if it's this ADL spreadsheet, then I'm going to say that the bill draft we voted on and requested bumps us up on the category, because the state of Utah has one mark on here: data collection. That's all they have. So if we just ask to draft the same law that the state of Utah has, and we pass that, if this is anything like the master list that everyone looks at, we'll be moved up on the list. So I won't, and I'm saying that somewhat facetiously, but to the point that I don't think we're not doing nothing or we're not doing anything. I do think it's a step forward to continue the conversation.
Co-Chairman, just great comments. There is a motion on the floor with a second and discussion on the motion. Does that, I don't think that there's a motion on the floor. Does everyone understand the motion? Everyone heard the motion? Discussion on the motion? Representative Provenza.
Thank you, Madam Chair. I would propose a friendly amendment to the motion to add disability and.
It's already been moved. I would encourage everyone to stop the side chatter and focus in on the committee work. It's very hard, and I know it's late in the day. This is why it's important to be timely with comments. So the committee does good work. We probably still have another 2 hours of work to do before we will be able to adjourn for the day. Point of clarity. A motion is on the table. It's been seconded. Further discussion?
Sure.
Representative Yin.
If I may have a friendly amendment on my own motion, if the second is in favor, just make it match the 1964 Civil Rights Act list and leave it at that. Thank you, Madam Chair.
Does everyone understand the motion? The motion is to amend our current statute in Title VI to reflect all of the protected classes found in the Civil Rights Act of 1964. All those in favor, please say. Second, since it's friendly. All those in favor, please say aye.
Aye.
All those opposed say no.
No.
That motion has passed. Further work on the topic? Representative Provenza.
Madam Chair, I would like to motion to have a bill draft to have the AG's office, Victim Services, provide some sort of reporting mechanism that isn't mandatory through law enforcement.
Is there a second? Discussion? I don't think LSO would know. The AG's office doesn't do bill drafts. Only LSO does bill drafts, Representative Provenza. And so we would need to be very specific. If you want to work with the AG's office and coming up with some solutions to bring at our next meeting, you can do that. Probably the best result there is my discussion on that. Further discussion? All those in favor of Representative Provenza's motion that I don't think is workable, please say aye.
Madam Chair, can I withdraw the motion then? If we
Withdraw your second?
Rather than having a vote on that.
Do you withdraw your motion as well?
Yes, Madam Chair.
All right. That motion is withdrawn. Further actions on the topic? Seeing none, that topic is closed. Committee, we're going to take a 5-minute break and come back. We will come back at 4:55. All right, let's call the meeting back to order. Committee, we're doing some good work here. We're going to begin our next topic, review of Wyoming Supreme Court opinions for purposes of the committee's knowledge. I've spoken with LSO and have really, we're going to focus our evening on only two cases right now for this particular meeting. The Board of Trustees versus Board of County Commissioners and Doctor versus Lozano. Those cases seem to be probably the easiest for the committee to kind of understand, digest, and maybe for us to take some action on. And we will then move the other three cases forward. And there also might be some other additional cases that the committee may work on as well. So just for the committee's understanding for this evening's work, so we can get out of here at a reasonable hour, we'll just work on Board of Trustees versus Board of County Commissioners and Dr. V. Lozano. Senator Kolb, the Board of Trustees, Board of County Commissioners is for you. So committee, hope that's satisfactory to everyone and recognize the hard work that we've done all day. And with that, Co-Chairman Olson would like to make some comments.
Thank you, Co-Chairman Nethercott. I just want to take a little bit of time to debrief a little bit and thank the committee for especially our newer members, and especially newer to Judiciary. Not all committees get to hear the impassioned testimony and subjects that Judiciary gets to hear. And so just really appreciate everyone. I know at times it got a little testy, and that's just a reality. And we move on to the next topic. And, you know, I suppose I really can't control what the public says and doesn't say, but I would just offer my friendly reminder on behalf of the Wyoming legislature to our public that when you come before the legislature, I think it's a tremendous opportunity, and we're here to listen, and we're here to hear from you. And I think that we have to be respectful of those testifying, and those testifying ought to be equally respectful. And I think that's the Wyoming way. And when we function in the Wyoming way, we'll do good things for Wyoming. Thank you.
All right, thank you, Co-Chairman. With that, Mr. Fuller, if you would like to start us off with Board of Trustees of Laramie County versus the Board of County Commissioners and give us the brief overview, I appreciate it. Thank you.
Sure, Madam Chairman. And just a couple of prefatory comments, kind of the background of this. This is something the committee has done for the last, I would say, 2 or 3 years after one particular case involving theft, where the Supreme Court explicitly invited the legislature to consider that issue. Since then, the committee has examined various cases where the court has interpreted statutes or has considered the legislature's intent in enacting statutes. And these summaries that are provided as part of the meeting materials are just simply overviews of those cases and just, considerations for the committee to consider. The committee can take whatever action it wishes or no action at all, as it has done in the past for some of these cases. So the first case, Board of Trustees versus Board of County Commissioners, this is 11-02 is a summary, 11-07 is the case itself. And this case concerns the authority or the ability of a Board of County Commissioners to dissolve a fair board. And statute, it's 18-9-101, grants each Board of County Commissioners the authority to, among other things, appoint a Board of Trustees to control, maintain, and manage the fairgrounds and to conduct certain fairs and exhibitions. Statute provides requirements for the establishment of the Fair Board of Trustees, including the number of members, their terms, their residence. The board can remove a member for cause, and the Fair Board is a body corporate and has perpetual existence once it files its incorporation papers with the Secretary of State. And it's not necessary to file any other certificate after the first one is filed upon initial organization of that Fair Board. So in this case, Laramie County created a Fair Board. In November 2018, the Board of County Commissioners passed a resolution to dissolve the Fair Board and created an events department to take its place. The Fair Board filed an action. They sought a declaratory judgment as to whether the county commissioners had the authority to dissolve the Fair Board. The district court in that case held that the county commissioners had implied authority to dissolve a board that they were granted the power to create. And the district court noted that that dissolution power is necessarily and fairly implied from and incident to their express power to create the board in the first instance. District court also noted that creating a fair board is just one way to operate a county fair, but it's not the only way to do so. The Supreme Court disagreed and reversed. The court started out with the proposition that a county is a political subdivision and only has the powers expressly granted by the Constitution or statutes, or can be reasonably implied from the powers granted. The plain language of 18.9.101 granted the county commissioners authority to create the fair board, but contrary to the district court's conclusion, the Supreme Court concluded that based on that statute, that is the only way that a board of county commissioners can conduct a county fair is through the creation of a fair board. And a county can either exercise that permissive authority by creating a fair board or not appointing a fair board, which would mean that no entity has authority to conduct a county fair. Because a statute delegated power to a local entity with a specific procedure to follow in exercising that power, and in light of the restrictive approach that the Supreme Court takes to interpreting county powers, the court concluded that the commissioners lacked the implied authority to dissolve the fair board under these circumstances. The court didn't consider whether the commissioners have authority to dissolve the fair board in the event that the county commissioners decided not to continue with the county fair. So Madam Chairman, members of the committee, I think that the considerations based on this case for the committee to consider would be, I think, first, whether statutory authority should be granted or specified for the dissolution of a fair board, and if so, what that looks like. And perhaps second, whether some other entity could operate or maintain the fairgrounds or operate a county fair. And then a corollary to that would be, what parameters should be in place for the dissolution. So for example, the disposition of any assets that the fair board may have or outstanding obligations. With that, Madam Chairman, I'm happy to answer questions.
Thank you, Mr. Fuller. Representative Washut.
Thank you, Madam Chair. Mr. Fuller, is there anything that would prevent a fair board from being assigned additional duties? Are they limited in statute to what duties they can perform? I know they have a number of duties that are listed, but is that all inclusive, or is there wiggle room enough there for a county commission to give them other assignments beyond running the county fair?
Mr. Fuller.
Yep, Madam Chairman, Representative Washut, all the statute says in terms of that authority is just appointing a board of trustees to control, maintain, and manage the fairgrounds. Can you appoint a board to, take on additional duties that are not incorporated in statute? Given the Supreme Court focusing on, the express language, the county only has the powers that are expressly provided. That may be difficult. Certainly though, counties, create, I think, different departments to, maintain different things. I think the issue in this case was, creating a different entity to operate something that statute provided a separate mechanism, a specific mechanism for.
Senator Kolb.
Thank you, Madam Co-Chair. Yeah, I've got a bit of experience with this, and I'll just be brief. As a county commissioner for 8 years, and others have longer experience than I, we had to deal with some of these same issues, the same questions actually. And it was always the opinion of the Board of County Commissioners that if you had the ability to create, you had the ability to dissolve. And it's clearly not in statute. And I think that's really the crux to the matter. Whether they want to create another entity is, is a side issue, I think. My thought off the cuff would be is to under 18.9.101, do just add language that can or can be dissolved, to be clear about it. Now, the question about debt might come up. Say that county fair board has acquired debt. Well, in Frank, the debt that they acquire was approved by the Board of County Commissioners. So in fact, they're responsible for said debt because they approve that debt, the structure of the, say, the county fair board to the Board of County Commissioners. So I think they have the responsibility then to figure out how to handle the debt and resolve that if they wish to dissolve a fair board. If they want to create something else in its place, well, I don't know if we have to contemplate that. I mean, we could, but I think maybe it might be two issues. One is the ability to dissolve and be clear statutorily they have that ability. And then add language that says that they're responsible for settling all debt, or, you know, some way of articulating that. And then beyond that, if we want to have a conversation about, well, what do you want to do to, instead of calling it a county fair, which is what we're really talking about, is a county fair. That's why it's Board of County Commissioners preview of, you know, having one or not. So I think maybe that's a starting point. Maybe I'd be happy to, I guess, share what I know about this and questions that people may, other legislators may have. And I'll end it with that. And, you know, Madam Chair, take any questions if you wish.
Representative Washington.
Thank you, Madam Chair. Senator, I guess my question would be if a board can be just dissolved at the whim of the county commissioners, why do we need to specify the idea of a fair board in statute at all? Let county commissioners run their counties as they see fit. And we don't need any language in the statute pertinent to a county fair.
Well, we could, but it's current language that's sorry, Madam Co-Chair, Senator Washington, or Representative Washington. Sorry, I didn't mean to insult you there, sir. So we could, but I think we have language and structure already in place in a system. So this would be a simple fix to it. And I guess we can skin the cat a number of ways if the group thinks that's appropriate. But I think there's a simpler fix here. I mean, there's a whole structure that's in place about Board of County Commissioners and their powers and authority. And this would mesh into there. And I would really go a little bit broader, is that any board that the Board of County Commissioners has the authority to create, they have in fact the authority to dissolve, where it would go hand in hand with all of these type of boards, to be clear statutorily that they have the authority to do that. Because without the clarity of the statute, they have the authority by fiat, which means the legislative body gives them the authority to do what they do. So if it's not expressly stated in statute, they don't have that authority. I think that's really the major hang up here. And so that's, I guess, what I know about that. Thank you, Madam Chair.
All right, further discussion or questions for Mr. Fuller? Representative Craigo?
Madam Chairman, question for Mr. Fuller, actually. So did we look at all the other entities, and I think Senator Kolb was just talking about this, that are subsidiaries of the counties, and I can think of several. Representatives Wannister just said one: parks, museums, airports, and I'm trying to think, there's
libraries.
Libraries, yes, that's the other one.
Madam Chairman, memorial hospitals. And the only reason, Madam Chairman, my apologies.
Go ahead, Mr. Fuller.
And the only reason I bring that up is Madam Chairman, Representative Craigo, there is a specific statute for the dissolution of memorial hospitals. And if I recall, I think that's the only place in those statutes where we have a specific mechanism for dissolving an entity that the Board of County Commissioners creates.
Representative Craigo?
Follow up, Madam Chair. Mr. Fuller, so when we were talking about memorial hospitals, does that fall under hospital districts, which have their own mill levy and have an elected board versus an unelected board?
Pointed.
Madam Chairman, Representative Craigo, these are, I believe, separate entities that are under Title 18, specific to counties.
Thank you, Mr. Fuller.
Senator Kolb?
Yeah, I believe that case that you just, the statutory change came out of Carbon County. That they were that was where the need was first changed statutorily for dissolving hospitals. It was, and I think more to the point, though, it was removing board members. That was the issue there in Carbon, about in the hospital, in a county memorial hospital, to be specific, not a hospital district. So thank you, Madam Chair.
Representative Washit.
Thank you, Madam Chair. Just a question. If a county commissioner, a board of county commissioners chose to dissolve their fair board, is it your understanding they would still have authority to operate a county fair by some other means? Or would dissolution of the county fair board mean cessation of a county fair?
Senator Cole, would you like to?
I can answer that because I thought about this. It would mean there would be, quote unquote, you couldn't call it a county fair as it is in statute. I mean, they could probably call it anything they like. If they want to have another organization say have a county fair, but under statute, when they create one, I think that's the I think traditionally what we think is a county fair. Sweetwater, or where I'm from, it's a large county fair. A lot of places, though, it's a small 4-H get together, but they could probably call it anything they like. I don't know, is anybody challenge them? It's how it was formed under statute. I think that what would count for the technical name of the entity.
Any further discussion? Representative Larson?
Yeah, thank you, Co-Chair. Currently, I don't know who to ask this to. You appoint the board members, the county commissioners, and can you take a board member off, I guess would be my question, before their term's over.
Mr. Fuller?
Madam Chairman, Representative Larson. So current statute provides that the county commissioners can remove any board member for cause. But I believe that trustee can ask for a hearing on that. If they are to be removed for cause, I think they can ask for a hearing before that happens.
Mr. Fuller, do you know, are those fair board members volunteers or are they paid? And only can be removed for cause.
Madam Chairman, I don't see anything in the statute that talks about compensation.
Representative Swanitzer?
So this, I think everyone knows this is in our county, or my county, and the two people next to me, and I've gone back and forth, but I really think when you read the statute, and where I think the Supreme Court got it correct, is in 189101(4). If the Board of County Commissioners may appoint a fair board, but it looks like if you want any money for that fair and you've levied any taxes that you're putting on your county residents, the statute clearly says can only be expended by the Board of Trustees you've appointed. So you have a choice of appointing them. Apparently the counties may take them out, but if you've levied any taxes in the county, the statute says only that Board of Trustees has the power to expend that funds, not even the county commissioners, which I think is fascinating and probably should not be in there, but it is. So is the question before us, because I'm new, to have a bill draft to amend the statute, should we see fit? Because I do think it's a fascinating discussion, but I think the Supreme Court probably got it right, even though I was upset with the decision being in Laramie County.
Yeah, so Representative Swanitzer, Mr. Fuller provided some background too, and the genesis of reviewing Supreme Court opinions came from me as an idea for an interim topic where the Supreme Court identifies that can specifically call out the legislature and say, hey, the legislature has the power to do these things, and it's their intent or their will to do this or not do this, and we're going to interpret the law accordingly. And so in those cases where the Supreme Court has done that, I have asked those cases to be brought before this body to ensure that if the court has interpreted the statutes maybe to have an error or to be ambiguous, like in this case, potentially an argument could be made that the statute is ambiguous because did we just fail to include a dissolution provision in the statute for a fair board? Was that an oversight on our part, or was that intentional on our part? That the county commissioners could never dissolve the fair board of which they appointed and created. It goes on in perpetuity, and the county commissioners no longer have any control over it. They can only remove members for cause based on terms. Is that the only oversight authority that the county commissioners has? And was that our intent when we created the Fair Board statutes and giving that authority to county commissioners? If so, okay. Or if it was an oversight, should we add a dissolution provision allowing for county commissioners to dissolve a Fair Board under certain requirements, under dissolution provisions? So that's really the question before the committee. And so how that all goes back to, that's how that applies in this case. So actually, when we review these cases, is to understand what the problem was. Is there a legislative solution that makes sense based on the statutes? And this would be one of those potentially. And we don't have to take action on these either. It's a choice for us to do. But certainly one that an issue that made it all the way to the Wyoming Supreme Court, created a lot of, I think, heartache within a community, even the community the size of Laramie County. And so it's not improbable. I think all the counties have fairs, or at least the majority of the counties have fairs and fair boards, that this would be an issue that is reasonable to occur again. And is it something that the county commissioners would like to have the ability to have more control over or not?
Madam Chair. Would now be the right time to propose a bill draft?
Sure.
I would like to propose a bill draft on the disillusionment of all boards that are created by the Board of County Commissioners and their ability to dissolve said boards. And secondarily, language to be developed to deal with the tax issue of the tax collected for that currently only can be dispersed by a fair board, and to try to have a all-inclusive system to accomplish this change. Because I might add, what really, I mean, that philosophical question here is should the one board Board of County Commissioners that created said entities, shall they basically rule in perpetuity over any current new board? I mean, I think that's the real question here. You have a new Board of County Commissioners, and they are in fact a new board, and they're locked in by what a past board did. And I think if we want to lock them in forever and have them like a statute that can't be changed, if that's what we want to do, then I suppose that's what we did. We wouldn't change anything. But I would certainly like to have a discussion on it in a bill draft. Thank you, Madam Chair.
Senator Kolb, would you want LSO to do a bill draft that looks similar to how county hospitals are dissolved?
I think that would be a possible way forward. Keep it simple. If we already have language in place about disillusionment of a hospital, County Memorial Hospital, that might be a good avenue, Madam Chair.
Is there a second?
I'll second it.
Seconded by Senator French. Discussion? Representative Zwaniter?
I guess a question. So the statute currently reads, shoot, what is it? It is for Board of Trustees to control and maintain fairgrounds, airports, parks, and pleasure grounds. Not sure exactly what a pleasure ground is, but it sounds inappropriate. But would we expand the bill? I'm not sure if we're going to treat a fairground board separate than an airport board. So would it be the bringer's intent to expand that to the Board of Trustees in 189101(3) for those specific that have to have a Board of Trustees applied, we would have a dissolution mechanism for all of them? Or do we just want it for county fair boards?
All of them. Okay. Representative. Madam Chair.
Mr. Fuller?
Yeah, Madam Chairman, I just want to be clear. Does all of them refer just to those listed in 189101(a)(3) that Representative Zwaniter just listed, or all of them throughout Title 18? That clarification would be helpful. Thank you.
Senator Kolb?
Well, I would first propose all the ones the Board of County Commissioners have the authority to create, they would have the authority for disillusionment.
Is that friendly, Senator French? It is friendly. And Representative Zwaniter, discussion.
Yeah, thanks, Madam Chairman. I go back to that same issue where it deals with levying county taxes only being able to be expended by a Board of Trustees. And so I would almost ask for a separate bill draft if we don't want to, dissolve any board that a county can put in place, but another perhaps more specific one for any time they can put in what we consider a Board of Trustees to oversee an infrastructure that gets taxes levied on it. because the rest of the statute does talk about the power of the Board of Trustees when a county commission appoints a Board of Trustees to oversee one of those projects. So I think there may be a difference in how broad we want to go. But it could be in the same bill draft if we want.
Craigo.
Thank you, Madam Chair. Just a point of clarification, I guess, 18.8109, which is the dissolution procedure for memorial hospitals, which I think we said we wanted the bill draft to follow, actually provides that the Board of Trustees, the current Board of Trustees decides whether to dissolve the board or not. And that really takes the power away from the county commissioners, which I think is what Senator Kolb is wanting to do. So I just wanted to point that out.
I think that's fair, Representative Craig, when I looked at that, but certainly LSO, Mr. Fuller can understand that difference. I think that the county commissioners would have the ability to dissolve. I think further discussion on the topic probably, and we can do this at the next meeting if a bill draft gets created or not, but the rationale for having the differences. So obviously the Fair Board are their trustees and also fiduciaries of the public's money and operate separate and apart from the commissioners. So some of those may be separation of powers concepts and different sources of funding and different duties, just to consider before we go down this path. Was there, and I guess I would ask LSO maybe to go back and look at any legislative history. If there was anything to indicate that it was intentional to omit the dissolution, or if it was potentially an oversight. And of course, you're looking for something that may not exist. Yeah. Further discussion, Representative Yen.
Thank you, Madam Chair. So my only worry is that if we say that a county by majority resolution could dissolve Teton County's airport, I'd be a little worried that it would be that quick. So I just want to make it a little, I just want to make sure that we take proper consideration in determining how easy or tough it should be to dissolve any specific board.
Representative Washut.
Thank you, Madam Chair. I would just simply ask that if this motion passes and we get a bill draft for our next meeting, that the LSO reach out to county fair boards and invite them to participate at our next meeting, so we hear their perspective.
Representative Larson.
Madam Chairman, thank you. I'm not excited about this bill or this proposal. I guess I would want some teeth in there also, that if this is a proposal by the county commissioners, that there ought to be a notice in the paper. There ought to be a chance 30 days down the road that they have a public forum. And I don't know if that should be an amendment or if it can be, but that does worry me.
Senator Kolb.
Well, I do agree that it should be a process that's open to the public's aware of it. The public has a chance to comment, and they go through those procedures to get that data in. I don't know about the Fair Board folks, because they were appointed by the Board of County Commissioners, to be on that board, and there are volunteers and they're non-compensation. And just to be clear about what it takes to be removed for cause means nothing. Cause means you come in, they protest, you have a hearing, you listen to what they say, and you remove them. There is no actual cause written down on the removal of a board member.
As an attorney, I would object to that.
Thank you, Madam Co-Chair. But that's what that means. But I do agree, we should have an open and public process that it goes through for the dissolving of anything that was created by the Board of County Commissioners.
Senator French.
Thank you, Madam Chair. Having been a commissioner for 18 years, dealt with a lot of this, and Representative Larson has a good point, but the commission meetings are always public, they're advertised, and anything of that substantial nature that you're going to potentially dissolve a board that you appoint, the commissioners appoint the members to, will be thoroughly advertised, discussed. It's not going to be a executive session type deal. the public would have ample opportunity to weigh in on it. Any Board of County Commissioners worth their salt would have public hearings on it in the communities and to thoroughly discuss it and get input.
Further discussion? Senator Cost.
Thank you, Madam Chair. And even though I do not disagree with the statement that it's going to be widely published and all, I still think it's a good idea to make sure that it's out there, because it's too easy for an agenda to have it slip through the cracks and all of a sudden become part of the agenda without anything else, and it's a done deal. I think I think it needs to somehow be stated in the statute that there must be a time limit for the review and all by the constituents.
So right now, there's a bit of confusion with the process. Senator Kolb's motion was fairly simple, then heard some comments and agreed with those. So Senator Kolb, are you maybe modifying your motion to provide a dissolution procedure that has additional notice requirements and hearing requirements potentially? And if so, let's hear your thoughts, Senator Kolb.
Yes, we should include additional requirements for public notification for the disillusionment process. I think we can work that in a bill draft further down the road, but I think if we put it in there, seeing my intent would be that, I mean, as the bringer of this bill draft proposal. Thank you, Madam Chair.
Friendly with the second. Okay, further discussion? Sensing you're ready for the question, all those in favor say aye.
Aye.
All those opposed?
No.
Chair is in doubt. I'm not sure if it's the room or all those in favor, please say, raise your hand. Eight, and all those opposed, please raise your hand. So, are you just doing the math? I remember, Mr. Fuller. That motion has passed with a vote of 8-6. All
Madam
right,
Chair.
Representative Yen.
Madam Chair, I just wanted to point out maybe for Mr. Fuller and for the committee, so 10.5.203 actually allows for the dissolution of an airport board, and there are restrictions around that. So maybe that could be something that the committee considers as we work on a bill draft. That there are restrictions around the dissolution, and make sure that we aren't super capricious about a dissolution of any one board.
Good thoughts, Representative Yen. All right, with that, we'll move to the next case for the evening. The doctor case, Mr. Fuller, if you're prepared. If not, give you a chance.
Thank you, Madam Chairman. The next case, Doctor versus Lozano, this is a little different in that the court kind of made a decision based on how other states' case law has established. This is 11-04 for the summary, 11-09 for the case itself. And put succinctly, the issue here is whether for purposes of claims of negligence or malpractice against public defenders, satisfying the exoneration rule is a prerequisite for maintaining a malpractice action against that attorney. Just to provide a brief bit of background before getting into the exoneration rule in the case, Wyoming has enacted a Governmental Claims Act, and this act provides that kind of the baseline is that, the state is immune, but the state will waive its immunity from suit in certain situations as matters of public policy. One of those is any immunity in actions based on a contract entered into by a governmental entity is waived. Governmental entities can purchase liability insurance to cover any acts or risks as provided under the Governmental Claims Act. And if that insurance exceeds the limits of liability that are specified in the act for occurrences of negligence or wrongdoing, or if that insurance covers any action or liability that's not authorized by the act, the governmental entity's liability is extended as the coverage provides. So with that, the exoneration rule generally is that a criminal defense attorney cannot be sued for malpractice in a case that results in the conviction of the attorney's client unless the client has been exonerated on direct appeal or through post-conviction relief. Many states have adopted this rule and require a defendant to gain relief from the conviction before bringing a malpractice action against their defense attorney. Some states require a former client or a defendant to prove both exoneration and actual innocence before being able to pursue such a lawsuit. Other states require a defendant to show that, but for the malpractice, a jury would not have found that person guilty. Now, a minority of states have rejected the exoneration rule. So that is, defendants could bring a malpractice action without being exonerated or before being exonerated. And those states that have done that have described concerns with the exoneration rule as a legal fiction with serious analytical flaws, concerns about the statute of limitations and extending cases, because post-conviction relief could take many, many years to be resolved, extending out that statute of limitations, but also preserving the role of remedies, allowing relief from a conviction. And again, that's a minority of states that have rejected that rule. So in this case, Wyoming public defenders were appointed to represent a defendant and did represent that defendant in a criminal trial. The jury convicted him. The defendant appealed, and an appellate public defender was assigned to represent him. While that appeal was pending, the defendant in this case filed pro se motions for a new trial, and a public defender was appointed to represent the defendant in those motions. The Supreme Court affirmed the conviction while these new trial motions were pending. And then when the district court held a hearing on those motions, the state public defender objected to any public defender representing the defendant because the state public defender's office wasn't statutorily required to represent the defendant once his appeal had been decided. The district court agreed with that interpretation, and the Supreme Court affirmed. After that, the defendant sued the public defenders under the Governmental Claims Act. And the public defenders moved to dismiss. They argued that his claims didn't fall under any of the exceptions to the state's immunity, and alternatively, that Wyoming should adopt the exoneration rule and dismiss the lawsuit because the defendant had not received relief from his convictions, his criminal convictions. The district court agreed on both points and dismissed the case. The Supreme Court reversed. And the court started by noting that the defendant's complaint adequately alleged that the public defenders had insurance coverage. I assume in this case, malpractice insurance, that would cover his case. And because the district court dismissed on a motion to dismiss, the Supreme Court, the district court, they're required to look at the complaint and the facts in the complaint as true, as being true. Then as for the exoneration rule, the Supreme Court took the minority position and rejected the adoption of the exoneration rule. And the court listed several reasons for that. The court noted that damages to a guilty person was a faulty premise, and that a defendant who prevails in a malpractice action isn't profiting, but is instead receiving compensation for an injury suffered at the hands of that person's attorney. The Supreme Court noted that Wyoming courts are well equipped to review and consider and dispose of malpractice cases. The court noted that applying the exoneration rule would be contrary to Wyoming statute of limitations case law. The court noted that adopting the exoneration rule would require the tolling of that statute of limitations until a criminal defendant receives post-conviction relief. And then at that point, a public defender or defense attorney would have to defend claims for actions that took place potentially many years ago. The court noted that the success or failure in post-conviction relief may have a preclusive effect on a malpractice suit. But the court noted that was a question to be decided on a case-by-case basis. And the court noted that district courts could stay malpractice actions while post-conviction relief is pending and leave that within the district court's discretion. The court noted that any concern about inconsistent judgments between, say, post-conviction relief and a malpractice action were inapplicable because both have different standards of proof. Madam Chairman, members of the committee, with that, I think the broad considerations here would be whether the exoneration rule should apply to malpractice actions, and if so, whether other requirements, for example, an actual innocence requirement should apply. I think another consideration is whether this would apply more broadly than just the Governmental Claims Act, to all claims of malpractice. The one final thing I would note, Madam Chairman, is that my research showed that this question of the exoneration rule is one that seems to be almost universally adopted through case law, and that any statutes that deal with exoneration seem to focus on that question for purposes of compensation for wrongful conviction, which I would note is a separate issue than what this case is considering. With that, Madam Chairman, I'm happy to answer questions about the case.
Questions of Mr. Fuller? Representative Zwanitzer.
Thanks, Madam Chairman and Mr. Fuller. So as I'm reading the decision, the court declined to make a judgment call on the exoneration part. So if every other state is doing it on case law, I can't tell, the court has in this case decided that it's an issue they want the legislature to solve, or did they take some type of affirmative to put it in place in case law like other states have done?
Mr. Fuller.
Madam Chairman, Representative Zwanitzer, what the Supreme Court did in this case was, and I would read this as explicitly rejecting the exoneration rule as a requirement in malpractice actions. I think this case is in particular, the wrinkle with this case is that it dealt with public defenders. So there's this implication of the Governmental Claims Act, the role of those provisions concerning contracts for insurance and the extension of liability to encompass any insurance coverage for other actions as well.
Representative Provenza.
Thank you, Madam Chair. Mr. Fuller, was there any conversation, and maybe I missed some of this, but like the constitutional right to a fair trial and counsel, is that violated by saying, so are we violating that by saying if we are not going to allow for this person didn't have a fair trial because their public defender didn't accurately do their job, I guess, then are we in violation of that if we're requiring actual innocence? Because it's not innocent people have a right to a fair trial, right? It's accused people.
Mr. Fuller.
Sorry.
Yeah. Madam Chairman, Representative Provenza, I think I understand the question. At least as it pertains to this case, I don't think that issue was a consideration. I think that issue certainly comes up in the post-conviction relief. If a defendant says they didn't get a fair trial because of ineffective assistance of counsel, that would be the consideration, in the direct appeal, in the post-conviction relief. In this case, I am not sure that that at least factored into the court's decision.
And I think Mr. Fuller, maybe if I understand Representative Provenza's question, the Sixth Amendment right to counsel and competent counsel is a separate issue, separate and apart from a defendant's ability to sue for malpractice. And so this issue is about a defendant's ability to sue for malpractice. And the question kind of before us in this case is whether or not we should adopt the exoneration rule, which would require that the defendant be exonerated before they could sue their attorney for malpractice, essentially. Yeah. And so do we agree with the Wyoming Supreme Court in their rejection of adopting the exoneration rule? Or not? That's the question. Representative Zwanitzer.
For either Mr. Fuller or yourself, because I know you practice, does it make a difference in your mind if it's a jury verdict versus, because I'm looking at the gamut of different, guilty verdicts on what type of malpractice you could allege. And I'm trying to decide in my mind if it makes a difference if it's a jury trial or if it's a judgment. Does that make any difference in your mind, the level of scrutiny that should be applied?
Mr. Fuller?
Madam Chairman, Representative Swanser, I'll take a stab at that. At least in the criminal context, I think there are certainly arguments of ineffective assistance of counsel at various stages of cases. Ineffective assistance of counsel regarding a plea agreement, regarding a trial. I think, whether a jury trial or it's before a bench trial, the allegations would be against the attorney's conduct in conducting that case. In terms of witnesses, arguments, and so forth, or they didn't do this or they didn't investigate this matter. I think who the decision maker is, I'm not sure necessarily plays a part in that calculus.
I think the other issue for the committee to consider in relationship to the exoneration rule is the competing view for practitioners. As the committee has heard in the past, the public defender's office has a difficult time finding public defenders. It's difficult work. It's whether it's private or public. If we were to adopt the exoneration rule, it would arguably extend the malpractice statute of limitations deadline to the date that the defendant was exonerated, because that would be a triggering event for them to file a malpractice action, which could be decades later from the attorney's potentially failure to act or malpractice. And so an attorney could be liable to a defendant for malpractice or the state, if it's a public defender, for decades to come. And so as a policy decision, do we want necessarily a statute of limitations deadline that has a triggering event that's at some unknown date in the future? From a government perspective, that's a dangerous decision because of overhead and liability issues. For private attorneys, it's even scarier. But from the government's perspective, which the committee's interest is in, certainly that is something to consider, that there could potentially be a malpractice payout from a lawyer's misconduct 30 years ago. And again, it's just the right to a malpractice action. It's not necessarily compensation for being wrong. It has nothing to do with compensation for being wrongfully convicted, which is a different issue altogether. Senator Kolb.
Thank you, Co-Chairman Nethercott. I understand, I guess, the philosophy here, but at the end of the day, it's malpractice. It's justice in a way for the person who was misrepresented. So I really wonder, I understand it might take a long time in it, but the big scheme of things, all the extra benefits we had given the lawyers during this last legislative session, this small ding to that on the scales of money might not be that bad. Thank you, I'm sure.
Further discussion? Any action? Interesting topic. You can speak and say no action. You can just hear your thoughts on it. That's the way I know what to do. Otherwise, I keep kind of talking, thinking you're thinking. Representative Williams? Thoughts? No, ma'am. All right. Okay, with that committee, the issue is closed. Also, as discussed, that was the only two cases we'd get through tonight. It is 6 o'clock. We are only 2 hours over time. My apologies to the committee. With that, though, we will go ahead and transition to directives to staff. So right now we'll hear Mr. Fuller, who will remind us of all of the outstanding issues we have, which is always a bit overwhelming. Mr. Fuller, please.
And Madam Chairman, I'm only going to do today's actions.
Wonderful, wonderful.
So here's broadly what I have. A bill draft request for resurrecting the judicial workload bill draft that the committee considered last year. A bill draft for a new judge in the 7th Judicial District, a new district judge, I'll clarify. A draft for the creation of a unified court in Wyoming. A bill draft for the non-compete issue for bias motivated crimes, one bill draft for data reporting as discussed with that based on Utah's law, and then amendments to 69102 to parallel the protected classes in the Civil Rights Act of 1964.
Wonderful committee. There's only one issue that I have in my notes that may from a follow-up from yesterday that I'm not sure we checked the box on, which was, and I believe Representative Washit alluded to it, but maybe a more of an action item for our next meeting, which is the CHINS Act, which to make sure we add to our agenda item, kind of the distinction between the need to look at the scope of the CHINS Act as it relates from a child in need of supervision to a child in need of services. And maybe just evaluate those limitations and make sure that that particular topic gets on our agenda for next meeting.
Yeah, Madam Chair, and I'll prepare a paper on that.
Thank you, Mr. Fuller. Okay, any final things anyone has in their notes? Representatives Monitor?
Thanks. Are we taking up the other 4 cases then Supreme Court to the next meeting?
Correct. Yeah, since we didn't get to them. And so we might just run out of time as a result of being out of time. So it goes. Committee members, you have done a phenomenal job. We had 2 difficult and very different days from each other, and I applaud your professionalism and I applaud you holding in. I think we've done some great work for the people of Wyoming, and I'm very proud of all of you and appreciate all of the work that we've done. At that, we will see you at the next meeting, August 30th and 31st, up in the Bighorn Basin, Powell, Wyoming. A location picked as a result of how many of our members on the committee actually are from that area. So we look forward to a wonderful and warm reception in the Bighorn Basin. Again, great work on our first interim, and it's going to be a great interim for all of us. A wonderful thank you to our LSO staff who has worked tirelessly and I know wanted to be home in about an hour, driving into their garages and seeing their families. So thank you again for this delay. Judge Wilking, thank you for being with us and providing such solid expertise. Appreciate you making us a priority with your time and understanding this process. Thank you. And again, happy birthday to Representative Ember Oakley, a huge asset to this committee. Safe travels home, everyone.